That's what I was looking for you, for your sake. Yeah. Saying this because you then gain half an hour to gain half an hour to go. Yeah. But anyway, it didn't work. I tried. Do you think they're not coming now? Yeah, but you I want to know, do you think they're not coming for this night? I think they're not coming for this night. Well, because
Let me just ask you. Do you know what time the judges are starting? Do you know what time we're starting? Okay. Oh no, apparently they're intending to start as well, but they just don't.
So where's the most senior? Yeah. Which is? Ishmael. And then on your right hand side. This is less senior, eh? Who packed this? Must I confess?
Ki Ishmael ne? M-O-D-I-E-A.
Must I confess this one?
Yes, please. D-I-B-A.
There.
Yeah, that's most junior. Lebkhang.
With an H in it.
I think with the G. I'm not too sure.
And the other one?
And the other one is Mahomet Ishmael. Mahomet Ishmael. I-S.
Muhammad with a U or
M-A-H-O. Mahomet.
double A.
This is hard labor.
Was I right? I was right, eh? Senior, second senior, third senior. Oh. But no, let me. Yeah. As I push this away.
No, that's what it stays.
Oh, so you just want to put the box there. And the box? What's that mean? So then the less senior must have walking first.
Senior judge was first, then she followed, and then this one followed.
Yeah.
I'm concerned.
Yeah, I'm gonna put it in here. Then it's not gonna slide. Yeah, I don't know who did this now. Just push it up and lift it up how? Like this. I don't know. You see, it's the SABC. Look there. This is short. Okay, then let's turn it. Look, we turn it. izinto zakamudiba. Huh? Now I'm confused. This is Ishmael's stuff, ne? Ishmael financial group this side.
But why?
I don't know. And they waiting outside.
But it's supposed to be.
Judge Wakuti would gonna sit in the middle. No, well, he said Judge Wakuti must sit in the middle. So I guess that's what we're doing now. Yeah.
Why?
Which Ishmael is gonna sit here. Ne?
That's what you want. I'm not
Yeah.
it anymore. Like, what they want, they can move their stuff.
It's very, yes. Do you know what I mean?
She needs to sit where you sit.
Exactly.
Now I look like in the middle now.
Oh yeah, that's yours. That's yours, ne?
Nice. Did you bring when I look?
Ini? No. Must I move the chair around? Hey. Did you move the chairs?
Yeah, no, Nelly man, I'm sure your judge was Woody.
Aren't you just sitting in the middle now? No, I don't know what to do.
There's no
Because she can't get up now and fetch it.
He's gonna give it. Because you can't put it at the back. No, I can't. So annoying, but I'm so annoyed. I'm just
I'm going to need you guys to spread out these documents on the table.
wait, sit on.
Yes, like, see there?
Wait, the council. Wait, this first stuff?
You see where me and Lisa are sitting? Just spread them out. Judge, I took the liberty right now. Spread out the documents. Whatever she needs, we'll just have to turn around and give them to her. Because otherwise, having Ishmael pass them around. I sent it to you by the index. It doesn't make sense when you're on your phone, the picture.
Yeah. No, I'm saying if it's his financial budget, sort of, so if it's give it to her, now we're going to
But I think are you correct on the next one?
of 2022 in the application of the President of South Africa, this is Jacob Zuma and others.
May it please the court, I appear together with my learned friends Ms. Muvangwa and Ms. Sokela for the applicant.
May it please the court, my lords and my lady, I appear for the first respondent in this matter, together with my learned friends Mr. Muela, Ms. Mamwepa, Mr. Mabungu, and Ms. Pamasiunu. As the court pleases.
Thank you.
As it pleases the court, TF Mativeli together with Advocate Kim Mute and M. Nduli, we appear for the second and third respondent in this matter.
Justices, I appear together with my learned friends, Ms. Kaisen Howi, Ms. Salome Mangana, and Ms. Tulena Makula.
Thank you.
Oh, sorry, for the amicus court.
Thank you. You may start, Mr. Manager.
As the court pleases, my lady and my lord, as you are aware, this is the application for final relief by the applicant. What I propose to do is to address the following topics. The first is to refer the court to the relief that we seek in the amended notice of motion. And secondly, to deal with a number of preliminary objections that the first respondent has raised. The first is the applicant's locus standi. The second is whether the civil court has jurisdiction to determine the matter and grant relief. The third is whether the application is in any way premature. The fourth is whether the amendment to the notice of motion to seek a final interdict is valid and of force and effect. And then I will deal with the merits. Under the merits, I will deal first with the question whether the private prosecution is valid. And the second, I will address the relief that we seek, the declaratory orders, the review and setting aside, and the final interdict. And to start then with the first topic, the amended notice of motion the court will find at page 911 of the papers. And you will see that the first prayer that we seek is a declaration that the summonses that were issued by the first respondent on the 15th and 21st of December 2022, respectively, both of them, to the extent that the first both of them are unlawful, unconstitutional, invalid, and of no force or effect. And we pray in paragraph 2 that the summons be set aside. And the third relief we seek applies only to the extent that you find that the nolle prosequi certificates that the first respondent relies upon, first, are still of force and effect, and secondly, that they relate to the applicant or a charge against the applicant. To that extent, we will seek that those nolle prosequi certificates be set aside, and I will deal with the grounds for that. And that's paragraph 3 and 4 of the notice of motion. The fifth prayer we ask is that the private prosecution by the first respondent against the applicant is set aside. And sixth, we ask that the respondent be interdicted from instituting any further private prosecution against the applicant on the basis of the complaint that forms the subject matter of the charges in the summons and is limited to the complaint in the summons. And I will address why we submit that we're entitled to a final interdict in that regard. If I can turn then to the preliminary issues, and I start with the question of locus standi. My learned friend wants to address the court. He's asked me to.
I'm sorry, my lords and my lady, it's my fault. I omitted to indicate to my learned friend that this morning that we made a decision. We're no longer pursuing the issue of the amendment. The fourth
Point in limine.
The fourth point in limine, yes, just so that he doesn't waste his time on it. I apologize to the court.
Thank you.
Thanks. It's not often that my learned friend offers gifts. I'm very happy to take it with both hands. So I deal with the question of standing, and as the court knows, that is the objection to the applicant's legal standing to come to court in the first place and engage the court's time. Our submission overall is that this objection is underpinned by a misapplication of the law and not a proper engagement with the common cause facts. And we will submit by reference to the proper test for standing and the facts that are common cause that indeed the applicant has standing to engage this court and to seek the relief that he seeks. We understand the argument by our learned friends to confuse liability and standing. So at the core of it is the applicant in his individual capacity has criminal liability as distinct from his office. And so the office can be before the court to challenge the criminal prosecution. And we submit that that is to put the inquiry in the wrong way because there is a distinction between liability and standing. And I'll explain why there is standing in the current case. We are concerned here with own interest standing because the applicant doesn't purport to represent, to act for any association or the public interest per se. He is here to assert his own rights, and in that sense, he must satisfy the court that he meets the requirement for own interest standing. And then the starting point then is what is the test for own interest standing? The first point to make, my lady and my lords, is that the common law test for own interest standing was direct and substantial interest. That has been rendered more flexible by the Constitution. Under the Constitution, the test for own interest standing is more broader, more flexible, the insistence that a party must show a direct and substantial interest. And that was set out in the case of Giant Concerts CC vs. Ronaldo. I forgot one thing of housekeeping, and that was to hand up a bundle of authorities to assist the court in respect of additional authorities that I would like to refer to. I'll ask that the bundles be put up. We've given our learned friends also the bundles. Thank you.
Are these the authorities that were uploaded on case lines
They were
overnight?
indeed.
Because I saw documents coming through at 1 a.m., 3 a.m.
Quite. Some of those authorities were authorities that were already there in the Part A case and were referred to in the heads, but we thought it would be more efficient use of time if we put them together and handed them up to the court. But there are additional cases, for instance, on this question of standing. And the other housekeeping matter that I didn't indicate is that I'll deal with the main case, and my learned friend Ms. Muvango will address the amicus submissions. So I'll leave her time to do that.
Okay.
So if I can take the court then to, in that bundle, to page 027-399, and that is the judgment of the Constitutional Court in Giant Concerts.
This is the bundle you've just handed up.
The bundle I just handed up.
Page reference again?
027-399.
I don't have 399, do you? Do you?
So it will be 027-399. So
Have you got it?
the machine is touching in. I beg your pardon. The court's pardon.
My bundle ends with 395. Yeah,
Let me
we all
just
don't
double
have
check
it.
that.
Our bundles end with 395.
I'm just checking that. Yeah, it seems that
that page
there was a
is-
problem with the printing, yes.
Is an extract from the Criminal Procedure Act. It's not a judgment.
That is, we will correct that in the course, but I'll take you to the passages. I'll just read out the passages that I rely on. Is the mission? I must wait. Yes, please. It looks like it's 380. So
380.
the numbering changed from the one I have, but I'll also be able
Found
to
it.
take you to the right passages. Yes, 380. Thanks for that indulgence. I'll wait for the machine to come on. Lady and Manuels.
380.
380. So it's 027 380. All the section is 027 throughout, and then it's just the page numbers perhaps that I can refer the court to. So it's 380 that I'm referring to, and it's Giant Concert CC versus Ronaldo Investments Pty Limited. I'm just waiting for signal that I can carry on. Generally, recording argument is probably not very helpful for the judges, but I've been told to wait.
Yes, you may.
Oh, I can go. So the first point to make about the judgment is that, and this is the post-constitutional law standing test, is that what the applicant has to satisfy you on is that his interests or potential interests are directly affected by the unlawfulness sought to be impugned. So his interests or potential interests are directly affected by the unlawfulness sought to be impugned. And in determining this question, there are a couple of principles from the judgment that I wish to highlight. The first is paragraph 32 of that judgment, and the court will find that at page 385. You'll see it says, in determining Giant standing, Giant relied on the standing under Paja, but the principle regarding standing applies across the board. And in determining Giant standing, we must assume that his complaints about the lawfulness of the transaction are correct. This is because in determining a litigant standing, a court must, as a matter of logic, assume that the challenge the litigant seeks to bring is justified. As Wooster explains, the issue of standing is divorced from the substance of the case. It is therefore a question to be decided in limine at the outset before the merits are considered, meaning you will decide it when you consider the matter before you get to the merits and not confuse it with the merits. But you must assume that the case is made out for the challenge. And then the second point is what is said at paragraph 37, because it's of particular relevance to the present case. And it's the same page. It says, the object of the standing requirement, the court held, was that courts should not be required to deal with abstract or hypothetical issues and should devote its scarce resources to issues that are properly before it. The court held that own interest standing does not require. They were required to answer questions that might incriminate them and which might later be used in evidence against them. This meant that the provision directly affected their interests, even though the direct interest lay in the potential impact of the challenged provision on their interests. Since no prosecution was impending or threatened, their wish to secure a ruling on the provision was not hypothetical or academic, but raised a real and substantial issue. They therefore had sufficient interest in having it resolved. So it's concerned with avoiding courts being engaged in academic and hypothetical cases. And the case also makes clear that it's not the case that in every instance you can only establish own interest standing if you are the person whose rights will be infringed. You can still show own interest standing if you can show that although you're not the person, the threatened challenge, the threatened breach of rights may potentially impact your interests. And the second paragraph I want to refer the court to is where the court now summarizes how the principles on standing at paragraph 41. It says, These cases make it plain that, that's page 386. These cases make it plain, and you recall, you will see later when you read the judgment, it dealt with cases in Eisenberg and Kruger, where even a practitioner in a particular field of law was entitled to standing, own interest standing, to challenge legislation in his sphere of practice. And that shows the extent to which the court construes the requirements for standing under the Constitution. At 41, it says, this case make it plain that constitutional own interest standing is broader than the traditional common law standing, but that a litigant must nevertheless show that his or her rights or interests are directly affected by the challenged law or conduct. The authorities show A, to establish own interest standing under the Constitution, a litigant need not show the same sufficient personal and direct interest that the common law requires, but must still show that a contested law or decision directly affects his or her rights or interests or potential rights or interests. B, this requirement must be generously and broadly interpreted to accord with constitutional goals. C, the interest must, however, be real and not hypothetical or academic. And D, even under the requirements for common law standing, the interest need not be capable of monetary valuation, but in a challenge to legislation, purely financial self-interest may not be enough. The interest of justice must also favor affording standing. E, standing is not a technical or strictly defined concept, and there is no magical formula for conferring it. It is a tool a court employs to determine whether a litigant is entitled to claim its time and to put the opposing litigant to trouble. If each case depends on its own facts, there can be no general rule covering all cases. In each case, an applicant must show that he or she has the necessary interest in an infringement or a threatened infringement. And here, a measure of pragmatism is needed. And 42, the impact of the Constitution on own interest standing is evident from Ferreira, Eisenberg, and Kruger. However, it is in my view necessary to emphasize that in each of those cases, the own interest litigant showed that his or her interests or potential interests were directly affected by the action sought to be challenged. It should be noted that the own interest provision in Section 38A is not isolated. It stands alongside 38B and E. These provisions create scope for public interest, surrogate, representative, and associational challenges to illegality. The risk that an unlawful decision could stand because an own interest litigant cannot establish standing is diminished by the fact that broad categories of other litigants not acting in their own interest are entitled to bring a challenge. And 43, the own interest litigant must therefore demonstrate that his or her interests or potential interests are directly affected by the unlawfulness sought to be impugned. Now I turn against that to the facts, against what are the potential interests that would be impacted by the unlawful prosecution. And I say unlawful private prosecution because that is the starting point. You've got to assume that the applicant has made out that case. He's made out the case too that the unlawful private prosecution breaches or threatens to breach his constitutional rights, which are enumerated in the affidavit. Against that, what do you have by way of facts? The first important fact is how the applicant cites himself. He says, I'm an adult male and President of the Republic of South Africa. So he tells you that he is an individual and he occupies an office. And you will find that in the founding affidavit at paragraph 1, at page 517, I don't need to take the quote there. He does the same in the supplementary founding affidavit at paragraph 1, page 866. So the court has a human being before it who occupies an office. That human being is a bearer of constitutional rights under the Constitution. You don't lose them because you become a president. This form of citation is exactly the same as that which is applied by the first respondent, former President Zuma. He describes himself as an adult male, former President of the Republic of South Africa. Seems to be the way at the union buildings. And the applicant further says, I am cited in a private prosecution. You must accept that fact, that he is speaking for himself. He says, I'm cited in that private prosecution. That's the same individual who occupies the office of president is cited in the prosecution, and you will find that in the founding affidavit at paragraph 2 at page 517. And then he says, the criminal charges are founded on an alleged failure to act in respect of Mr. Zuma's request to him in his capacity as President of South Africa to investigate complaints against Mr. Downer and other prosecutorial officials of the National Prosecuting Authority. So he says to you, the conduct for which I am charged relates to my failure to discharge a function of my office. And that's the way in which I was requested to act. And you will find that in numerous places in his founding affidavit, the court can look at paragraphs 24 to 25 of the founding affidavit, paragraphs 30.8 and 31, paragraph 69 of his founding affidavit. In his supplementary affidavit, you will find it paragraph 15 and paragraph 62 to 71. And then he alleges that the unlawful private prosecution breaches or threatens to breach his constitutional rights. And you will find that in the founding affidavit, also at paragraphs 93 to 94. I'm skipping the page numbers because they're numerous places. Paragraph 93 to 94. And in the supplementary affidavit, you'll find it paragraph 100. Sorry, it's still the founding affidavit, paragraph 100. And then in the supplementary founding affidavit, you'll find it, it's paragraphs 79 and 80. We submit that as an individual occupying the office of president, when his rights are threatened, his human rights are threatened or breached as he alleges, he's got standing to institute proceedings in court to protect his rights by having the unlawful conduct declared invalid and set aside. And that's in line with the giant concepts test. We submit that even if the court were to look at him as cited only in his official capacity as president, there are sufficient facts which establish that even the office, so to speak, the office, not just the human being occupying the office, has a direct interest in the potential impact of the unlawful private prosecution. The first impact of that private prosecution on the office of the president is that, as he alleges, it will result in an undue interference with his duties of office. And you will find that at paragraph 94 of his founding affidavit at page 558. And the second, he alleges that the private prosecution, unlawful private prosecution, will have an adverse impact in the confidence in the Republic and confidence in the office of President. And you will find that at paragraph 113 of his founding affidavit at page 563. Now, just stopping there, you have sufficient facts to demonstrate that on the broad constitutional standing requirement, even the office has a direct interest in the continuing unlawful private prosecution. So he meets the standing requirement at both levels, as a human and as an occupant of an office. But as a matter of law also, the President has a constitutional obligation in Section 83B of the Constitution to uphold, defend, and respect the Constitution as the supreme law of the Republic. He has that function in his official capacity as an occupant of that office. And defending the Constitution includes defending respect for the rule of law, which is the founding value under our Constitution, Section 1C. And this case involves a defense of the rule of law. It is a proceeding in which the applicant seeks to assert the legal requirement under the CPA in Section 7 and Section 9 that a private party has no automatic right to institute private criminal prosecution against another party without complying with Section 7 and Section 9 of the CPA, which embodies the requirement of legality of the rule of law. And this application vindicates the rule of law and therefore falls precisely within the realm of the duty of the office of the President, if one looks at it as simply a constitutional institution that is before the court. And it would be entitled, there would be a direct interest in the office of the president ensuring that the occupant is not unlawfully criminally prosecuted, because that prosecution would have an adverse impact on confidence in the office and the functioning of the office. So we submit that the standing point really has no merit whatsoever. It is not a point that should even be detained in the court. Allied to that objection, they attack the right of the state attorney or the authority of the state attorney to represent the applicant in these proceedings. Of course, that, whether it's well made or not well made, has nothing to do with standing. It doesn't undermine the president's standing. All it means is that he may have standing, but he should have used private lawyers. But even that, with respect, is an unfounded objection. And the case that's relevant to when the state attorney is entitled or indeed obliged to represent a party is the case of Zuma versus Democratic Alliance, which we have included in the, both parties actually cite that judgment. It is to be found at page 471. And this emanated in the many court cases that the former president is involved in, one of which is the criminal prosecution which is taking place in KZN. In respect of that prosecution, the state attorney had hired a private law firm to represent the former president at state expense. So instead of the state attorney being the attorney to represent the former president, a firm of attorneys was instructed by the state attorney to act for the president. And the question was whether that was in line with the requirements of the State Attorneys Act and whether the state could be held to the expense of that kind of representation. And the court said no. And the reasons it said no with respect are set out in this judgment of the Supreme Court of Appeal in Zuma versus yes, and that judgment dealt with section 3(1) sub 1 and section 3 sub 2 of the state attorneys sub 3 of the State Attorneys Act, which regulates when the state attorney may act for a party. And I want to refer the court to paragraphs 36 of the judgment. It's 36 to it's starting from paragraph 33 on page in this, that will be page 477, 33. It says that, so it refers to section 3(1) and 3(3) at paragraph 32, which are the sections which authorize the state attorney to be involved. And it says just below 32, the functions of the office of the state attorney and of its branches shall be the performance in any court or in any part of the republic of such work on behalf of the government of the republic as is by law, practice or custom performed by attorneys. And then you have 3(3), which you'll see at paragraph 36 is quoted. Unless the Minister of Justice and Constitutional Development otherwise directs, they may also be performed at the State Attorney's Office or at any of his branches like functions in or in connection with any matter in which the government or such an administration has aforesaid, though not a party, is interested or concerned in, or in connection with any matter where, in the opinion of the state attorney or any person acting under his authority, it is in the public interest that such functions be performed at the said office or at the one of his branches. So if, in the opinion of the state attorney, it's in the public interest that the state attorney should perform the functions of an attorney in relation, in this case, to the applicant, then it is authorized to do so. And you'll see at paragraph 37 it discusses that. So the point that you ask is whether there is any government interest or public interest in the application to set aside a private prosecution against the incumbent of the office of president, with respect, and in connection with the alleged failure to perform his official functions as president. With respect, we say the answer is self-evident, that there is public interest in ensuring that the president performs his functions as required, and he is not prosecuted unlawfully for the performance of his function, and that he is not subjected to an unlawful private prosecution by a private individual. There is a direct public interest in that, and the government is certainly interested in that. The office of the president that he occupies has a direct interest in such a proceeding. So the state attorney is quite rightly involved in this case to act for the president. So we submit in summary that the objection on standing both of the president as an individual and as an occupant of the office, and the objection to the state attorney's involvement are all unmeritorious, and the court should not hesitate to dismiss them. The second in limine point is the question of jurisdiction. My lady and my lords, this question has been decided by the full court in the interim relief application. We accept that when a court sits in order to consider interim relief, generally the findings it makes are not binding on a subsequent court determining the same issue. But my lady and my lords, the question of jurisdiction stands on a different footing. You will know from established authority that even any judgment on jurisdiction, whether it is on exception or it is on an interim relief, where the court says, I have jurisdiction, that finding, that judgment is appealable because it is final in the old sense, as in the Zweli case, the old sense of finality. So, I recall the Mays Board judgment which went to the SCA on an exception, that the court said because the exception turned on a question of jurisdiction, the finding made on jurisdiction was dispositive, because you're not going to reverse that and the court say, I don't have jurisdiction, the matter must go somewhere else. That is completely final. So with respect to our learned friends, the starting point is not on a blank page as it were. It is on the basis that you have a ruling of the full court, and they must persuade this court that that judgment was clearly wrong and this court must not be considered itself bound by it. They have attempted to do that. They raise about 4 arguments. We submit with respect that all of those arguments have no merit. In fact, they are not supported by the very judgments on which they rely, and I will demonstrate that.
Sorry, your submission is that Part A judgment is binding on this court.
We submit that the ruling on jurisdiction is a binding ruling, but we're not suggesting that the court can't revisit it. The court is entitled to find that, yes, there was a ruling, but it's clearly wrong, we're not bound by it. As in the usual rule on stare decisis is that the same, as this is a full court and that was a full court, you can find that that judgment was wrong, and therefore you must determine the issue of jurisdiction afresh. We're not suggesting that this court mustn't hear the objection. No, we're not saying that. We're just saying that we're starting off with a judgment, and our learned friends have the burden to show the court that that judgment is clearly wrong. But we are happy to contend that even if there was a clean slate, that judgment is clearly correct on the authorities which it cited. And the authorities that our learned friends say are to the contrary by the SCA and the Constitutional Court are in fact not to the contrary. The first point on which we all agree is that jurisdiction is determined on the pleadings and not on the merits. So even if we are wrong on all the allegations we've made, for purposes of jurisdiction, the court accepts the pleadings as they are and determines whether on the pleaded case there is jurisdiction. And you recall that that pleaded case in the nature of a challenge to the private prosecution is firstly that it doesn't comply with the provisions of Section 7 and 9 of the CPA, because there was no underlying nolle prosequi certificate that justified the issuing of the summons by the registrar. The Act is very clear. No private prosecution will take out a summons without a nolle prosequi certificate. And we will be submitting to the court that although there is on the face of it a nolle prosequi certificate, on all the common cause facts, it's clear that that nolle prosequi certificate had nothing to do with the applicant, nothing to do with the president, had to do with other people. That's the first point. The second point we make, and I'm just doing this for purposes of jurisdiction. The second point we make is that the private prosecution is for an ulterior purpose, constitutes an abuse of court process. The first respondent lacks a substantial interest in that prosecution because the charge is frivolous and vexatious, and we will come to that and I will debate that point. So one must, and then he alleges that all of this taken together, you have a private prosecution that is in breach of the rule of law, which threatens his constitutional rights, and he asking the court to intervene. Against that backdrop, the question is whether the civil court has jurisdiction to determine such an application. That is the point. And just to summarize how we understand the argument for our learned friends, they say that the judgment in the interim relief application relies on high court judgments of various divisions and not judgments of the SCA and the Constitutional Court, when in fact there are in place judgments of the SCA and the Constitutional Court which go the other way, which establish a rule that a case that starts off as a criminal case, such as the present, cannot find itself in the civil courts. Now, we will submit that there is no such rule in the cases that they rely on, and there are two cases. There are two cases. The Moyo judgment, and that is a judgment of the SCA, and there is a judgment of the Constitutional Court, which our learned friends don't rely on, because that reversed the SCA judgment. And then the second judgment is the Tint judgment, which involved the prosecution regarding the arms deal. And I'll refer to that. That's the judgment of Justice Langa. He was acting Chief Justice at the time when he wrote the judgment, and there's a ratio there that they rely on. When I say that the SCA judgment in Moyo was reversed, I don't mean that the Constitutional Court reversed the particular sentiments expressed by the SCA in the paragraphs they rely on. What I mean is the outcome of that judgment and the reasoning of that judgment on the constitutional challenge that was before the SCA was reversed by the Constitutional Court. And then they also rely on the judgment of Nundalal, which we say support us. And then they also they say we rely on older judgments. When you rely on older judgments, somehow there's a breach of the rule of law, but that's really something we shouldn't bother with, because the Constitution only invalidates that which is objectively inconsistent with it. If the previous older judgments are still consistent with the Constitution, they still remain good law. They don't fall off because they are old. The fact that Solomon was decided in 1950 is neither here nor there. They also rely on Section 14 of the Superior Courts Act. By that, they criticize the judgment of the interim court to say, when the court says there that this court is one division, you don't have a criminal court and a civil court structurally under the Constitution or even under the Superior Courts Act. What you have is an organization on how the courts deal with criminal matters and deal with civil matters. And they refer to the Section 14 of the Superior Courts Act. I can deal with that summarily because Section 14 of the Superior Courts Act supports the reasoning of the interim court. The heading is manner of arriving at decisions by divisions. It tells you that you have high courts in various divisions. Then it tells you how the courts must be constituted when they deal with civil matters, or when they are sitting as court to first instance, and when they are dealing with criminal matters, they must follow the procedural provisions of the CPA. So they are not creating, an analogy here is this High Court versus the Labour Appeal Court or versus the Competition Appeal Court. Those are courts which have distinct jurisdictions by constitution and legislation. But this court doesn't have such a thing. It's correct that when you make decisions under Section 14, you will sit as a criminal court to make a decision. But any one of you, my lady and my lords, can sit tomorrow as that judge to determine the criminal case, as you are sitting today to determine the civil case. So it's not...
Mr. Manager, that's not how I understand the first respondent's case on this point. The issue he raises is about procedure. It's not about the type of court. It's more about procedure. And we well know that the procedure that is followed in the criminal court is very different from that followed in the motion court.
Yes.
What he is asserting is that the president, having been summoned, should have appeared in the criminal court, and only there may he challenge his title to prosecute when he pleads in terms of Section 106H, it is, right? H. That's his complaint.
Yes. Yes.
So
yes.
I think I'm of the view that the manner in which the court in Part A, the full court in Part A, as well as the judgments on which that court, we well know that civil and what distinguishes them is the procedure followed. And that's what this party is asserting here.
Yes.
So I don't think it should be simplified. It should be dealt with. It should be understood in the proper context, and it should be addressed.
Yes, Justice Madiba, I was not suggesting to trivialize the issue or not to characterize it properly.
Yes.
I was simply responding to what Section 14 deals with.
Yes.
I will come to the real objection about what the Supreme Court of Appeal and the Constitutional Court of Appeal, the Constitutional Court has said on the issue that my lady raises. So the only point I was making is to say that Section 14 does not create the division, but I accept that what it does is to say to the courts, when you're dealing with criminal matters, you follow the procedure under the CPA. Yes. That's absolutely correct, and I don't disagree with that. We accept that. What I'm submitting is Section 14 does not create a jurisdictional issue that one finds when you're comparing two distinct courts. I accept that at the level of...
How do you distinguish the courts you're referring to?
Yes.
What's the factor of distinction?
Yes. So the Constitution tells us the judicial hierarchy.
Yes.
It tells you there's the Constitutional Court, there's SCA, and there are high courts. And there are also courts of equivalent status as high courts. And those, for instance, will be the Labour Appeal Court and the Competition Appeal Court. And then it says legislation will determine the jurisdictions of those courts.
Yes.
Then you'll have the Labour Relations Act and the the Competition Act telling you what those courts' jurisdiction is, and it tells you these courts have exclusive jurisdiction on X, Y, and Z, and they have concurrent jurisdiction with other courts on certain matters. That's a hard, statutorily determined jurisdictional devolution between the various courts. What I'm submitting is when you're looking at the civil court in the High Court and the criminal court in the High Court, granted, they deal with distinct matters and there are distinct procedures that govern how they deal with those matters. But what you don't have is a clear demarcation by way of jurisdiction in any legislation. So there's no legislation telling you that only this part of the High Court deals with criminal matters and only that part of the High Court deals with civil matters. You don't have that. So hence the point I was making is that what the Section 14 does is to regulate how the same court will deal with those distinct areas when it is confronted with them. I accept that internally, once you've constituted as a criminal court, you follow the procedure under the CPA. That's a distinct procedure, no debate about that. And when we are here before you as a civil court, you're also governed by a distinct procedural framework. That's acceptable. But that's not a hard question of jurisdiction. The whole jurisdiction is about power. It's about whether the legislation allows the civil court ever to find itself enjoying the power to determine a matter which emanates criminally. In other words, in this particular case and all of those cases that the court has looked at where there is a clear violation of the CPA in terms of private prosecution, and I'm saying this because that's how you must assume for purpose of jurisdiction, does the legislation or the scheme of the legislation make it clear that the jurisdiction of the High Court to grant any relief is excluded when it comes to criminal matters? That is the hard question of jurisdiction. The question whether the preference is that criminal matters must be dealt in the criminal courts and civil matters must be dealt in the civil court is not a hard question of powers, is a question of preference. Is where do you best achieve justice? And you will see, in fact, in the judgments of the SCA and the Constitutional Court, that although they do decry the fact that even in public prosecutions, you have civil challenges in the civil courts. They say, but you can't close the door. You can't impose an absolute rule. It always depends on the interests of justice. So it's a flexible rule, it's a flexible principle. It is not a hard question of powers. If it was a hard question of powers, our learned friends would not even have to engage in this debate about what is preferable and what is not, and what has Justice Wallace J.A. said in that judgment or not. They would simply say to you, in terms of this legislation, the jurisdiction of the High Court is excluded from determining, and High Court, I mean Civil Court, is excluded from determining criminal cases. It is because they can't say that we're in this debate about whether, for instance, the point that my lady raises, is Section 106 the only route through which one can challenge the title of a prosecutor?
That, in my view, is the core question.
Yeah, but
it's not all these other issues that are being bandied about.
Right,
that's the core question.
Yes. And in dealing with that core question, my lady, I premise it, and I'm coming to it, I'm not running away from it, it's the core question, is one must look at the wording of the section itself.
Yes.
You will see that it is permissive. It empowers. It enables.
It's discretionary.
Yeah, it enables the accused to raise a defense.
Yes.
It doesn't say this is the only way.
Yes.
It excludes all other courts.
Yes.
That's the first point.
Okay.
And the courts, those courts that are old judgments, starting with Solomon's, and it's not old to the extent that it's been taken up by post-constitutional law judgments, say there is nothing in the Criminal Procedure Act that says the jurisdiction of the civil court is excluded. In other words, 106 is the exhaustive route through which, whether you're in a private prosecution or in a public prosecution, if you're complaining that your prosecution is unlawful, that's the route. That's the route, and that's the only route. As we read in the Bible, that's the only way. That is not what the legislation says, and that is not what the cases say. And against that backdrop, it's important to look at what the SCA and the Constitutional Court was saying, not dealing with Section 106, but dealing with the scheme that criminal cases must resort in the criminal courts, whether they actually established a hard and fast rule, because that's the only time that our learned friends will win this case, is that they must show you that there is a hard and fast rule which excludes otherwise the jurisdiction of this court, which has been established in all of those cases is referenced in the judgments of the interim court in this case. I start with the Moyo judgment in the SCA, and here I think case lines throughout our pagination a little bit, because we uploaded this and then we can't trace it now in case lines. But I'm going to read you this paragraphs from the reported judgment. We don't have a copy. We'll make a copy available during the. We'll look for a copy during the tea break. If we understand that our learned friends might have Moyo, because
I spotted it actually. It is there. It is on case lines. Just trying to find the reference.
But we'll find it. He's giving me the index. He's giving me the index. My learned junior says she also went to the same page and didn't find it. So we'll sort it out with my learned friend. He's always helpful. We'll do that. It's important to remember what that case was about. So somebody was charged with intimidation under the Intimidation Act, and they then raised a constitutional challenge to the definition of the crime of intimidation. So this was a public prosecution. It's not a private prosecution, for starters. And so along the way, as Justice Wallace was dealing with the merits of the challenge, he made this observation. Observation maybe is an understatement. He decried this, that every time a public figure is criminally charged, you see these challenges in the civil courts even before the criminal challenge can get off the ground, and that this is to be deprecated, because it's only those that can afford to have legal representation of the kind that you want to come with all sorts of challenges that then can afford that. The relevant paragraphs where he says this is paragraph 167 to 1. I'm just going to ask my. 170. Yes, I just want to get to the paragraph 167 to 170, more specifically 167 and 170. And it's important, perhaps, but the submission we make about the judgment is that, firstly, it doesn't set a binding rule that cases that emanate in criminal courts should never find themselves before civil courts. And secondly, he made it clear that the test is always the interest of justice. Our learned friend says the test is exceptional circumstance. That is not correct. That's not what the judgments say is the test. The test is interest of justice. So at 167, what the Justice Wallace says is, the reason advanced by both Ms. Soni and Mr. Moyo for not following the usual and ordinary course was the possibility of their being convicted and sentenced before the constitutional complaint could be adjudicated. This was which is a fair, good, weighty reason. This was advanced as the reason for raising the alleged constitutional invalidity before trial. I accept that if the trial had proceeded, there might have been some risk of this occurring, but a magistrate's court faced with a colorable constitutional challenge to the legislation under which it has just convicted someone would grant leave to appeal and consider favorably an application for bail pending the appeal. That diminishes the risk considerably. In any event, this argument creates a situation where the ability to have a constitutional challenge dealt with in advance of the criminal trial would depend upon whether the charge was laid in the magistrate's court or the High Court. If there was thought to be a real problem, the National Director of Public Prosecutions should have been approached to remove the trial to the High Court, where the case would take its usual course including disposing of the constitutional challenge. As a general rule, the departures from the procedures laid down in the CPA and the effective removal of criminal proceedings to the civil courts should not be countenanced. So, as a general rule, he's not saying it's not allowed. He's just saying the courts should countenance it. And then paragraph 170, he says, all of this conveys to me that the wisdom of Langa ACJ remains pertinent. There are echoes of that in Madlanga J's words in Savoy. The question in every case is one of the interests of justice. In my view, the interests of justice in both of these cases demanded that the High Court decline to hear them before the resolution of the criminal trials. Like my colleague, I deprecate the fact that the trial judge failed to address the point. However, like he, given that the proceedings have reached this stage, I considered it in the interest of justice to deal with the appeal. So it's always the interest of justice. But what the Constitutional Court did in the subsequent judgment, which we have included, and I don't need to dwell on that.
It's at 027.
372, yes.
No, 027 of case lines.
Oh, sorry, 353.
Item
Was my
30.
lady referring to the SCA judgment?
Concord.
The Concord, yes.
That's the one you said you couldn't find.
That is correct.
027, item 30.
Item 30.
Okay,
I'm indebted to my lady. Now, in the bundle we've given you, we've also included it, but it's a different page number. It's 353. But we've given it to you in a physical form as well. So the Constitutional Court judgment, and I might have missed a passage, I stand corrected, did not deal with those sentiments in paragraph 167 and 170. What it did was to deal with the constitutional challenge as a genuine challenge and to reverse the findings on the merits of the majority of the SCA. The majority had found that the legislation was capable of a constitutional interpretation, and the Constitutional Court that is to stretch the words used in that statute, and that is not permissible, it's unconstitutional. So it didn't complain that you shouldn't have raised a constitutional issue. The Constitutional Court dealt with the constitutional issue and found for the accused persons.
But the manner in which, or rather the Constitutional Court order in Moyo,
yes,
was dispositive of the trial, wasn't it?
Quite.
So it demonstrates, by implication, it demonstrates exactly the point you're raising.
Yes.
That there are cases where to ignore a frontal challenge and proceed with the trial may not be in the interest of justice.
Which is what those accused persons were saying, we could be in jail when in fact we are right on the constitutional challenge. And we would like to say with respect that this is the case you are facing, where when we go to the facts, you will see that other than the creativity of counsel, on the common cause facts, the nolle prosecute certificates that they rely on their own facts, does not relate to the president or a charge against the president. But I'll come to that. I'm not inviting the court to take me there. I'm just making the point that this case is a case where the interest of justice cries out for the court to intervene and avoid a clear abuse of court process and a clear breach of the rule of law. What the Constitutional Court said in Tilt, you recall that is the judgment that Justice Wallace referred to at the conclusion of his judgment, is included also in our bundle. We've included it at 332. Sorry, we're just checking where it actually is. It seems like there's a bit of hide and seek here. It's not where it's meant to be.
No, I see. 266. Sorry.
266. Yes, tint. You recall these are all those challenges to search and seizure warrants in the arms deal case also. And the relevant passages in this judgment is paragraph 64 and 66. And paragraph 64 the court will find at page 284. And you'll see.
Do you have the case line?
Sorry, I'm not sure that I'm at the right place. It might be 65 and not 60. Yes, I must refer you to 65 and 66.
Please confirm if the case line's reference is 027 item 27, is it? For the tint judgment.
Yes, I'm told that it is. And you'll see, again, the interest of justice. If my lady goes to paragraph 64, it says, the second reason why it is this is the interest of justice to grant leave, is that the second reason why it is in the interest of justice to grant leave to appeal is that it would be desirable to settle the law regulating overbreadth and undue vagueness of search warrants issued in terms of the Act. It is in the public interest to clarify the requirements for intelligibility laid down in Powell and to consider whether it is reconcilable with the approach of the majority of the Supreme Court of Appeal in these applications. But the point directly that we are concerned with is in paragraph 65, where the court says, I nevertheless do agree with the prosecution that this court should discourage preliminary litigation that appears to have no purpose other than to circumvent the application of Section 35(3), that's of the Constitution. Allowing such litigation will often place prosecutors between a rock and a hard place. They must, on the one hand, resist preliminary challenges to their investigations and to the institution of proceedings against accused persons. On the other hand, they are simultaneously obliged to ensure the prompt commencement of trials. Generally, disallowing such litigation would ensure that the trial court decides the pertinent issues which it is best placed to do and would ensure that trials start sooner rather than later. There can be no absolute rule in this regard. However, the court's doors should never be completely closed to litigants. If, for instance, a warrant is clearly unlawful, the victim should be able to have it set aside promptly. If the trial is only likely to commence far in the future, the victim should be able to engage in preliminary litigation to enforce his or her fundamental rights. But in the ordinary course of events, and where the purpose of the litigation appears merely to be avoidance of the application of Section 35(5) or the delay of criminal proceedings, all courts should not entrench it. The trial court would then step in and sufficiently constrained from acting unlawfully by the application of Section 35(5) and by the possibility of civil and criminal liability. The nature and degree of unlawfulness of the search warrant are important factors to be borne in mind for the purposes of a decision under 35(3). It is for this reason that the same court should consider the unlawfulness. So the point that I make here is the same point in, and then that goes on at 66. That you can hear it in the criminal court because it is also an impartial court, but you can't have an absolute rule that you can't raise challenges in the civil court, because in some cases the interests of justice would favor that, in the sense that there could be a definitive finding, and so you don't close the door to the litigants. And that applies equally to the objection to the prosecutor's right to prosecute, because the prosecution is not in line with, does not comply with the Section 7 and 9 of the CPA. So here really what the court is invited to do in this sense is to determine whether the interests of justice favor that a litigant should be allowed to obtain relief, and especially where the complaint is a breach of the rule of law and a breach of constitutional rights. and the case is strong on the merits, and we will show why we say so, that a court should not shy away from upholding the rule of law. And here we can recall the dicta of the former Chief Justice Mogoeng in Mhlope at paragraph 130, where he says the rule of law is one of the cornerstones of our constitutional democracy, and it is crucial for the survival and vibrancy of our democracy that the observance of the rule of law be given the prominence it deserves in our constitutional design. To this end, no court should be loath to declare conduct that either has no legal basis or constitutes a disregard of the law as inconsistent with legality and the foundational value of the rule of law. Courts are obliged to do so. To shy away from this duty would require a sound jurisprudential basis. Since none exists in that case, and in this case we submit none exists, because the interests of justice we submit favor the court determining the matter. And all the other cases that our learned friends refer to case of CETA, State versus Zuma, Du Plessis versus de Klerk, and Nest versus de Preeters and Van der Beek, all in their heads of argument, do not concern jurisdiction in the sense that we are debating the issue today. So we submit that the old authorities, which are continued beyond the Constitution and are summarized in the interim relief judgment, remain good law and are not changed by the SCA or the Constitutional Court, both in the Moyo judgments and in the Tint judgments. And so this court must refuse jurisdiction in the same way that the interim court did.
If I understand you correctly, then in the submissions you just made, you're saying the jurisdiction is about power of the court to set aside illegalities committed prior to whatever prosecution private prosecutor wants to proceed with, and that this can be done in the civil court, whilst it does not preclude an applicant such as the present one from going to the criminal court and raising an objection to title in terms of 106H. Is that a correct understanding of yourself?
So if one looks at just title, yes, of course, if he decided to submit himself to the criminal court, he could raise the title under Section 106. But that is not to say that he's precluded from challenging the prosecution in advance, especially when his challenge is not limited to title. It's also that this is an abuse of court process. It's a prosecution for an ulterior purpose, and the prosecutor does not have any substantial interest in persisting with a vexatious and frivolous charges in a criminal context. So that's the point. We're not suggesting that there are no cases where a privately accused person chose to raise the defense in the criminal court, firstly, or that there are no cases in which an accused in a private prosecution was told you can raise that in the criminal court. The Netco case is the one case they rely on. That in that case, the judge said, if you're complaining about title, you can raise it under Section 106. But the very same court exercised jurisdiction to set aside the private prosecution on the basis that it was an abuse of the court process. So on the one hand, Netco says, yes, if you are contesting title, you can go to the criminal court. The usual way is to raise it in the criminal court. But that same court goes on to declare that very same prosecution unlawful and interdicted. Perhaps we can find that judgment and just give my lady and my lords the reference where that judgment is. I beg your pardon? Yeah, is at page 8 in that bundle we handed to the court. So you will see that the order that was granted in that court is at page 15, 27-15. In the result, it is ordered that the first respondent be and is hereby interdicted and restrained from proceeding with the prosecution in the Magistrate Court, Port Elizabeth, instituted by him under case number 2334-01. In the same case, the judge said, in relation to title, you can raise it also under 106. But there was a complaint that this was an abuse of court process, and the court declared that invalid and interdicted the prosecution. So it all depends also, Justice Butler, on the ambit of the challenge that is brought. Because if it is purely about title, and if the interests of justice weigh against the applicant, it might be a case in that particular case that a court might say, we think this is better proceeded with in the criminal courts. You raise your 106. But that, we submit that's a discretion the court has. But in this particular case, the NETCO case which they rely on, the court interdicted the very same private prosecution for being an abuse of court process. And
so in NETCO, was the challenge raised in the criminal?
In the civil court.
In the civil court.
Yes.
So the accused in NETCO did not subject himself to the private prosecution.
Right.
Is this the only case? Because I was looking for such a precedent. Is this the only case?
That's the case. There may be others. I can't recall if there are cases where, like in this case, the judge said you can raise the issue of title in the criminal court, but nevertheless interdicted.
No, I'm asking you a different question.
Yes.
Whether this is the only case where the accused opted not to subject himself.
No, it's not the only case.
What?
So the first case is Solomon,
Yes.
which is the 1950 judgment by Judge Roper. That my learned friend always smiles when I say 1950, but that judgment has been approved by, no less by the SCA, so it remains good law.
It has not been overturned.
No, not at all, my lord. And it's a judgment of this division.
You could not seem to think differently. Was it overturned?
No, never overturned. Yes. And the first judge, so that's the one judgment, and then there's the judgment which is page 1 of the bundle we've given the court, Van Deventer, yes. Van Deventer was a judge, involved a private prosecution against the judge for finding in a particular way. And that judge didn't subject himself to a private prosecution, challenged the lawfulness of it. And that was the order there was also that the private prosecution was interdicted and restrained. You will see the order is at page 6, paragraph 3. The first respondent is interdicted and restrained from proceeding and or continuing with or from taking any further steps pursuant to the said private prosecution in the civil court. And then there's the NETCO judgment that I just referred the court to, which is page 8. And then there's the prosecution and a statutory power. Recall there's also a statutory power to prosecute under section 8. That you will find at page 17. That also was declared invalid. That's where you could be prosecuted for ill-treating animals, and the NSPCA could prosecute you as a statutory body. That too you can challenge that in a, I'm told that is T. And then I've referred Solomon. So there are a number of cases. They all referred to in that interim relief judgment by the full court, and they have not been set aside. Not even the constitutional courts have said, but in private prosecutions you can't go to the civil court. None of them have said. And there are 2 points about jurisdiction that I can deal with quickly. The first one is this idea that the application is premature because the president must go to the criminal court and raise a section 106 defense. We submit that is not precluded from bringing a civil challenge, and I've referred to the courts, the judgments that I've just referred to. The second point is they say, well, we have failed to exhaust internal remedies under PAJA. But their starting point is completely wrong. We're challenging summons issued on the 21st of November and 21st of December 2022. The 6 months had hardly even left the station before we came to court. They're referencing a decision of April 2022, which is a decision not to prosecute. We're not here challenging the DPP's decision not to prosecute. We're challenging the first respondents and the registrars or conduct of issuing a private prosecution unlawfully, or alternatively, only if the nolle prosecute certificate relate to the president do we challenge those, and those were made in June 2022 and November 2022. So there's no issue of exhaustion of internal remedies under PAJA. In any event, that wouldn't apply to abuse of court process. You can't say you must exhaust internal remedies before you complain about an abuse of court process. So, my lady and my lords, I can pause there subject to the court's leave for the T adjournment, and we can proceed, and I'll then start with, I think, I'll deal with the merits.
There's a good time to pause.
As the court pleases.
We will be back at 22? 12.
Bridget? Bridget? No, there's only I've been in court before and we've got some strategy from one on TV. So, the banana. No, I don't eat bananas.
Mr. Manache, your approach is quite comprehensive, and we are benefiting from it, but we are concerned about time.
I will move quicker.
Given the outline that
Yes.
you've agreed to, you two should be concerned
Yes.
about time.
Yes, I'm very
So find a balance. I'm not saying change your approach. Find a balance, because we
Accept.
are finding it quite useful.
I accept. And I've been reminded by my timekeeper just here that I might run out of into problems. So just before I go to the merits, there's just, when the court asked me for judgments where private prosecutions were declared invalid, the other is Nundalal, which I didn't mention.
No, but Nundalal was in a criminal court. It went to the High Court on review stroke appeal. It's unclear what that was, because even the court questioned that but didn't make a definite finding regarding the procedure.
Yes.
But the frontal challenge was raised in the criminal court.
Yes.
So he subjected himself to the prosecution process.
Quite. The only point we make about Nundalal is the discussion of Section 7 and Section 9 in that judgment, that it's applicable here. Thank you. Then turning to the merits, you will see in the application that we challenge the summons and consequently the criminal prosecution, and then we also challenge the nollie prosecute certificates. I'm not going to spend a lot of time on the certificates, because we would submit primarily that it is clear on the facts that the summons were not underpinned by a valid nollie prosecute certificate which related to the president or a charge against the president. And so there are a couple of grounds of review, and I'm just going to mention them, and then I'll develop those that I will focus on in my oral submissions. The first is that the nollie prosecute certificate was not in respect of a charge against the president, and I just give the reference in our heads where we deal with that. That's paragraphs 35 to 49.3 of our heads of argument, and if the page numbering is correct, it's 1717. If it's wrong, I'll just give the paragraph numbering. And we submit that because of that, the registrar acted in breach of Section 72A of the CPA in issuing the summons without a nollie prosecute certificate relating to the applicant and a charge against the applicant. And that's paragraphs 53 to 59 of our heads. And then we make the submission that the first respondent could not have a substantial interest in pursuing a prosecution where the criminal offense is frivolous and vexatious, and I will make submissions why we say that. And we submit that goes to substantial interest, but also to the argument that it is for an ulterior purpose and it is an abuse of court process. So I'll deal with that. And then under the nollie, there are a couple of grounds. Firstly, the ground that the 6th June 2022 nollie had expired by the time that the summons were issued. That should go to invalidating the summons, but I just mentioned it under the nollies. And then we make the point that...
Which summons? The two summons?
The two summons, yes.
To the extent that to the first summons, no nollie was attached, right?
Yes. It was the June 2022 summons that was attached.
Was it attached?
Yes, to the first summons. To the first nollie, yes. To the first summons, the June 2022 nollie was attached, and then it was queried, but that is about Mr. Downer expressly and has lapsed. Then they issued the second summons, which attached the November nollie. And the key ground challenging the nollie, if the nollie certificates are interpreted to refer to the applicant, is that the issuing of the nollie in respect of the applicant would have been an irrational exercise of public power given the information that was before the DPP, because that information did not say that there had been a charge laid against the president that the DPP could decline to prosecute on. So that's the part in relation to the Nolly that I will make submissions on. But as I say, that's a secondary argument, because the main argument is this application must succeed on the basis that there was no Nolly prosecution certificate relating to the president. And I deal with that one first. Now, in Nundalal, there's a passage which is very important at paragraph 22. And that passage says that a certificate nolle prosequi is issued for a specific offense. And then there's an explanation as to why that is a requirement. I've got it as starting at 4593 on case lines, Nundala. And then the passage that I referred to, paragraph 22, is at 4601. And in that passage, says, a certificate is issued for a specific offense. It has a lifespan of 3 months, after which it lapses. This helps to enhance certainty and prevent abuse of private prosecution. The court may interdict a private prosecution on various grounds, including the private prosecutor's lack of locus and under the Vexatious Proceedings Act. But it makes the point that it is, a nolle is about a specific offense, and that tracks the language of section 7.1a, which requires that before a private prosecution can be instituted, the DPP must have declined to prosecute an offense or charge against a person. So, and the nolle is issued in respect of that offense, and this means that the DPP says, I've considered the affidavits and the documents that were presented and the charge that support the charge, and I decline to prosecute in respect of that charge. And here, with respect, you will find that the key documents, which I will refer the court to, show beyond any debate that the DPP did not have a charge before her in respect of the president, or in any sworn statements or affidavits that would have justified the issue of a certificate against the president. And the relevant factual background is largely common cause. You will find in the applicant's heads of argument at paragraph 6 to 19 a summary of the facts, and you will find in Mr. Zuma's heads at paragraph 19 a statement that they agree generally with the exposition of the common cause facts, but simply want to add some more facts. So the key facts are common cause. And we submit that the issue really tends on the proper interpretation of 5 key documents. The first document is Mr. Zuma's own statement laying the criminal charges, and that is at page 918 of the papers. Sorry, 917. It starts at 191. Yeah, I was right, 918. It starts at 918. You will see when the court reads that statement properly, you will see that Mr. Zuma here is complaining about prosecutors in his case, those working with the prosecutors, the investigators in his criminal charges, and then he also refers specifically to people, investigators who were named in an affidavit by Mr. Willy Hofmeyer. That would involve the tapes. You remember the famous tapes case, involved in that prosecution. He complains about all of those, the current prosecutors, the investigators, and references Mr. Hofmeyer's affidavit. And you will find that at paragraph 7 to 11 at page 921, where he starts complaining from paragraph 7. He says, I therefore report and seek that a criminal case be opened and investigated by the police and law enforcement officers in relation to the conduct of Advocate W.J. Downer, SC, a Senior Deputy Director of Public Prosecutions. I wish to extend my complaint of criminal wrongdoing to cover all other persons as reflected in the documents attached above, who are either prosecutors and or investigators who have violated the provisions of the NPA Act and the Constitution. And you see, he carries on at paragraph 8, says, the conduct that I demand be investigated by the South African police relates to the contravention of Section 4.1 of the National Prosecuting Authority Act, primarily but extend to criminal activities, particularly those reflected in the affidavit of Mr. Hofmeyer involving criminal interference in my prosecution by foreign spies with the assistance of local investigators and prosecutors. And then 9, he says, I have no doubt that beyond the criminal conduct involving the leaking of confidential information to persons outside the NPA, the scope of criminal conduct is far wider. And then he says, he particularizes the counts that he is raising. He says, at the end of paragraph 9, the last sentence says, the specific details of the criminal offenses which at this stage I wish to report for criminal investigation and prosecution are: count 1, on or about 4 to 13 June 2008, Advocate W.J. Downer, SC, unlawfully and in breach of Section 41 of the NPA Act, disclosed information concerning an investigation by the National Prosecuting Authority involving Mr. Jacob Zuma to another person, namely Mr. Sam Soul, a journalist who was at all times employed by the Mail and Guardian. And then count 2, on or about 9 and 10 August 2021, Advocate W.J. Downer, SC, authorized and sanctioned the disclosure by Advocate A. Brettenbach, SC, of a confidential medical report to One News 24 journalist Ms. Karen Mon. The report had been initially disclosed in an affidavit signed by Advocate Downer himself on behalf of the National Prosecuting Authority in relation to a then pending application for the postponement of the criminal trial of Mr. Jacob Zuma. The information came to the knowledge and into the possession of the prosecuting authority and members of its prosecuting team in the performance of their functions in terms of Section of the NPA Act. The leaking of this medical report and information was done without the written permission of the NPA Prosecution Director, NDPP, and therefore constituted a criminal violation of Section 41 of the NPA Act. And then there's a reference to preliminary analysis. You'll see at paragraph 16, he then referred to his plea that's going to take place in the Pietermaritzburg High Court, and refers to the judge presiding there. Says this settlement talks about this the sentiment that he could raise his objection to title under 106H. I think that's relates to that. He says this sentiment was also correctly expressed by the presiding judge in the aforementioned ongoing trial in which I'm the accused person. So he mentions the judge, but he mentions, he's describing events. And then at paragraph 17 he says the alleged conduct, that's the criminal conduct against the alleged conduct against the NPA and its officials. He says the alleged conduct also forms part of separate investigations which are conducted by the President of the Republic of South Africa, Mr. Cyril Ramaphosa, the Minister of Justice, Mr. Ronald Ramola, and or the Legal Practice Council. The relevant complaint letter written to President Ramaphosa and his response form part of the full papers in an application which I had brought to supplement my plea in my criminal trial. The full application is attached here to marked whatever. So you can see the context in which the judge is named, in which the President is named, the Minister of Justice is named, and the Legal Practice Council is named. It's not that they are suspects and there is a charge against them. And so that some statement is not the document that sets any charge against the President which the DPP needed to consider. And this supplementary affidavit that he refers to in his 106 plea is also in the record at page 927. That's okay, yeah. Okay. I've been asked to use the case lines references, so it's page 927, but the case line reference is 015-248 for the supplementary affidavit. You'll see that supplementary affidavit at paragraph 16 says the alleged misconduct perpetrated by Mr. Downer and the NPA in leaking the medical letter was reported to the President in a complaint filed with him and copied to the NDPP and the Minister of Justice. I attach a copy of the self-explanatory complaint. 17, I must point out that at the time of its leaking, The only person who was in possession of a physical copy of the report or letter was our lead counsel. He is the one who blew the whistle and informed the legal team and Mr. Zuma of what had occurred in the discharge of his professional obligations, and as such, he will give assistance to any investigation if called upon to do so. Then he says at 18, in response to Mr. Zuma's resultant complaint, the current President of the Republic has since informed us that he had directed that a full investigation be conducted on the NPA's conduct. We are awaiting from the Minister, recall he said, I'm referring this to the Minister to investigate, we are waiting from the Minister the opportunity to make an input in that process and have been instructed to place before him some of the evidence involving Mr. Downer and the NPA, which is already before this court, so as to demonstrate that the most recent conduct is part and parcel of long-standing behavior on his part and that of the NPA. A copy of the letter from His Excellency President Ramaphosa is annexed here too. I'll refer to those in a moment. But you can see that at this point, when Mr. Zuma files a supplementary affidavit, he is expecting to cooperate with an investigation that he knows the President has directed the Minister of Justice to conduct. So he couldn't, in the same vein, be alleging that the President is an accessory after the fact, or the President is engaging in unlawful conduct which constitutes a defeat or obstruction of the administration of justice. He sees him as advancing the cause because he has instructed a functionary, a cabinet minister to investigate, and in turn the LPC, which is responsible for the professionals against whom the former president complains, to investigate. So that's the supplementary. And then in line with all of this, to show that the president was not yet a suspect at the time when the sworn statements were filed, you will see that the nolle prosequi certificates themselves bear that out in the language that is used. And you will find the June certificate at page 705. I'm trying to find the case line reference on this one. I can't. It's 01.
It will also be 008-107.
It's 008-107. 008-107. You'll see that that certificate there says is a certificate in terms of Section 7.2 of the CPA. It tells you the DPP's Ms. Elaine Zungu, who has since deposed an affidavit here, that I have seen all the statements and affidavits on which the charge particularized below is based, and that I declined to prosecute at the instance of the state. She saw the sworn statement that I referred the court to, which names the judge and the president. You could never say, just because the judge is named and the Minister of Justice is named and the LPC is named, they're also suspects. In the same vein that you can't say the president is also a suspect. It says, it's in that certificate, the suspect is Mr. William Downer. The complainant is Jacob Zuma, Mr. Jacob Zuma, and the alleged crime is the contravention of Section 416 read with Section 417 of the National Prosecuting Authority Act, and the date of the alleged crime is 9 August 2021, and the police reference is PMB case 309/10/21. At the point when the certificate is issued, it refers to the specific date of the commission of the crime of which the complaint is made. That is the primary crime of leaking the documents. So it is not the crime of an accessory after the fact or obstructing the ends of justice, because that crime can only arise after the request by the former president for the current president to investigate. And you will find that request at page 676 of the bundle, and I'll ask for the case reference, for the case line reference. Yeah, the old is 676. That's where the request is made. It's made by the attorneys for the former president, and I don't want, it sets out the whole history of the matter, and then you will see where it ends with the request. It says, request for urgent inquiry and is at page 687, paragraph 27. I'm told that it starts at 001-170. 001-170. And the concluding request is this, is paragraph 27 to 29. It says, the purpose of this letter is to bring the above constitutional violations to your attention, on to request and/or demand that you take all the necessary steps to ensure the institution of an urgent investigation and/or inquiry into the conduct and/or alleged misconduct of the relevant public institutions and/or officials acting in their capacities as state functionaries. You'll no doubt appreciate that due to his official status of former president, our client's concerns as expressed above go far beyond the important issues of health and confidentiality, but also in related security concerns. We apologize for the length of this letter, which owes to our instructions to give you as full a background as possible regarding the serious issues raised in. And the background is all of these complaints that the former president has raised in numerous courts about how his investigation and prosecution has previously been interfered with, some of which have gone to the SCA and back. And then the president responded at 689. And the response is dated 25 August 2021. So it is shortly after he received the request on the 19th of August. That is at 001-183. And it says at 689, your letter dated 19 August 2021 on the above matter refers, we take note of the allegations of serious misconduct you made in your letter. We view these allegations in a very serious light and have referred the matter to the Minister of Justice and Correctional Services as the relevant cabinet member empowered by Section 1796 of the Constitution of the Republic of South Africa 1996, read with Section 33 of the National Prosecuting Authority Act 1998, to exercise final responsibility over the National Prosecuting Authority. We've also requested the Minister of Justice and Correctional Services to refer the matter to the Legal Practice Council in relation to allegations of misconduct by legal practitioners. You'll recall Mr. Downer is a legal practitioner, but so is Mr. Breitenbach, our colleague in Cape Town. And the letter to the Minister is also enclosed, my lady and my lords, at page 690, and that is 001-184. And that is, Dear Minister, is also dated 25 August 2021. I have received the attached letter from BM Tusini Inc. attorneys in relation to their client, former President Jacob Zuma. The letter raised allegations of serious misconduct against members of the National Prosecuting Authority. Section 1796 of the Constitution of the Republic of South Africa 1996, read with Section 33 of the National Prosecuting Authority Act 1998, requires cabinet member responsible for administration of justice to exercise final responsibility over the National Prosecuting Authority. Considering that the issues raised in the attached letter involves the conduct of the prosecutors, it may be prudent that you refer the matter to the National Director of Public Prosecution for further consideration. So that's the response. And that, we submit, explains why the nolle prosequi certificate are limited to the complaint against the primary contravention of Section 416 and 7. Because at that point, the President is doing what he's requested to do. He's referred it to the responsible minister and the LPC to conduct an investigation. And I must not digress, take you to the next nolle prosequi certificate, the November one, which is at page 983 and is case lines 015-73. This is the certificate on which the first respondent seems to base his case, because it now opens the certificate, as it were, to the world, any person. So the judge was named, the Minister of Justice was named, the LPC was named. If one takes a literal interpretation of any person, then all of those people are also within the realm of this nolle. But that can't be the way one interprets written documents. The SCA and the Constitutional Court have made it very clear. You look at wording, purpose, in context, and you do that simultaneously. So you have to understand this in the context of the sworn statements, the supplementary affidavit that was submitted by former President in the KZN court to understand whether it could conceivably, on any gymnastics, mental or otherwise, that this actually includes the president. It says this, it's a certificate in terms of section 7.2 of the CPA. I, again, the DPP, hereby certify that I have seen all the statements and affidavits on which the charge particularized below is based. You've seen the sworn statements. You've seen the particularized charge. It's also particularized here. It's a contravention of section 416 and 7, and it occurred on the 9th of August 2021. I decline to prosecute any person in connection with this matter. What is this matter? It is this charge for this contravention on this day. And that, as we submit, precedes the request to the President. It does not deal with a contravention as an accessory after the fact, because that is a self-standing criminal charge. At this point, in 9 August 2021, how could, want to ask a rhetorical question, how could the DPP have even thought that on 9 August 2021, the President was an accessory after the fact, or he was obstructing the ends of justice on that date, which is given as the date of the, unless she's got powers of divination, which only humans don't have. So we submit with respect, just on these documents, it is abundantly clear that these two nollies are not in respect of a charge against the applicant, do not relate to the applicant. And therefore, even if Mr. Zuma has a genuine gripe someday or other, he can't use these certificates to mount a lawful private prosecution. And for that, the registrar was wrong, was acted unlawfully in issuing this, because the law is very clear: no person shall take out a summons without a nolle prosequi. And that must be a nolle prosequi that is applicable to the person who you authorized could be criminally prosecuted by a private individual. So we would submit with great respect that the case actually ends right here, that just on this private prosecution is unlawful. And in fact, the nolle prosequi certificate of June 2022 that they rely on lapsed in September, before the summons were issued in November and December. The CPA is very clear. Unless you institute proceedings within 3 months of the issuing of that certificate, it lapses. The unless is conjoined with the timeline. It's not just unless in the ether. So we submit with great respect that there's a clear case of an unlawful private prosecution here. But the matter goes further than that. It shows that there is no potential criminal offense, because for both accessory after the fact and defeating the ends of justice, there must be unlawful conduct by the President regarding the request by the former President. But with great respect, when a President says, I take your complaint in very serious light, and I am referring it to a cabinet member responsible for the NPA to conduct an investigation, and to the extent that they are professionals, to the LPC. That is perfectly lawful, and it is consistent with our constitutional framework. Why do I say that? The Constitution says in section 85(2) of the Constitution that the President exercises executive authority in this country together with his cabinet ministers. That's the first principle. The second principle is that the President assigns powers and functions to ministers, and he has, acting in terms of that section, assigned the powers over the NPA to the Minister of Justice. The complaint is about the NPA, so he refers that to the responsible minister. What does the former President say in his affidavit to the court in KZN? He says, we are awaiting to hear from the minister about this investigation so we can cooperate. When did he change to decide that this is criminal conduct. I'm no longer waiting for the minister to come back in this perfectly lawful instruction of the president to his cabinet minister. It's only on the eve of the national conference of the ANC. That is what happens. And you will see in the affidavits that there is a suggestion about animosity, personal animosity by the current president of the former president. That's the underlying backdrop of this change. Because otherwise, how does a lawful instruction, which is so perfectly embraced in the affidavit to the court, not just a press statement, to the court, that we are waiting to cooperate, how does that change overnight to become criminal conduct? So we submit with great respect that this is the kind of case that falls squarely within the boundaries of an abuse of court process, ulterior purpose, and there is no substantial interest. And Nundalal helps us in this regard in considering what examples exist where a private prosecutor would lack a substantial interest. And you will see in the paragraphs from 30, 47, and 48, and it's useful just to go to those paragraphs, 30, 47, and 48. Because at paragraph 30, it says, in my pagination in 4605, it says this: constitutionally established under section 179 of the Constitution, the prosecuting authority's importance in the administration of justice is entrenched. It has the potential to trench on rights in the Bill of Rights. Subsection 2 entrenches its power to institute criminal proceedings on behalf of the state. Foreshadowed in subsection 3 is national legislation to detail the implementation of the exercise by the prosecuting authority of its powers and its functions. National legislation prescribes its obligations when a person seeks a private prosecution. The statutory requirements for a private prosecution in section 7 seek to avoid frivolous and vexatious prosecutions for the same reasons discussed above that public prosecutors may decline to prosecute. Usually they must be adhered to strictly to ensure a fair trial. A criminal prosecution, private or public, has consequences potentially invasive and destructive of an accused's substantive rights to, amongst others, personal freedom and security, and the right to a fair trial, of which the right to be informed of one's accused and the nature of the accusations are paramount. As a general proposition, the obligation to provide an accused with the name, description, and signature of the private prosecutor would be fundamental to the rights of an accused to fair trial, not least because the CPA prescribes them. And then paragraph 47 says, the concise Oxford English Dictionary defines substantial to mean of considerable importance, size, or worth. Substantial occurs in many statutes. It is unhelpful to suggest, as counsel for the applicant did, that substantial means the same as it does in substantial and compelling circumstances to avoid the imposition of a prescribed minimum sentence. Substantial must garner its meaning from the particular context in which it is used. In the context of section 7, substantial must refer to the interest being such as to be capable of resulting in a conviction. A public prosecution will not commence or continue unless a conviction is possible. There is no rational basis for setting a different threshold for a private prosecution. Irrespective of whether the prosecution is public or private, for a fair trial, an accused cannot be expected to mount any defense other than to stave off a conviction. Anything else would amount to shifting the goalposts in a private prosecution, thus creating uncertainty about what standard an accused must meet. A standard that differs between public and private prosecution and from one private prosecution to the next will not be a foundation for a fair trial. Paragraph 48. Correlatively, if the private prosecutor fails to prove that he has a substantial interest, then no private prosecution can ensue. An example of an insubstantial interest is if the issue is de minimis or frivolous and vexatious. The interest does not have to be of a nature to give rise to a civil claim, but it's frivolous and vexatious. This is the kind of criminal charge that is preferred against the president. With great respect, The courts are not there to be used for these sorts of cases, whether to settle political scores or to deal with personal animosity. That is not the place for the courts. The courts are here to defend the Constitution and uphold the rule of law under the Constitution. And this case calls for that interference by this court. And against that backdrop, I addressed only briefly the requirements for a final interdict. We submit that they are well made, that this must be interdicted, like in all the other cases that we referred the court to. If there's an abuse of process, there's no title to prosecute, or it's frivolous or vexatious, the court can grant an interdict to stop an abuse of process and to stop a continued infringement of constitutional rights. My lady and my lords, those are our submissions on the merits of the case, and so we ask for an order in terms of the notice of motion. And as I said, only in relation to the notice of prosecution certificate is only if the court were to find, contrary to our submissions and the submissions of the DPP, that it doesn't do so, doesn't relate to the president. There's one other document I omitted to mention, which my learned friend for the DPP will no doubt deal with. It is the supplement, is the affidavit of the DPP, which the court will find at page 1128. And I can just give the paragraph references. Paragraph 5 is relevant, paragraph 6.6 is relevant, and paragraph 9.4 is relevant. All of those, the DPP says, forget the wording and this and that and the other. What are the objective facts? The objective facts are that the documents that served before me did not contain a charge against the president. Therefore, I did not apply my mind to a charge against the president and declined to prosecute him. That's the end of the case, because this is not about debating the interpretation. Is the decision maker telling you what was before her and what she considered and how she discharged her office. And with respect, we submit that we shouldn't be having this debate before the court. This private prosecution is unlawful.
Mr. Amended, on the issue of the final interdict, I think if I paraphrase what the first respondent says, it is not sustainable because it would unfairly or unduly circumscribe the rights that the first respondent has to proceed otherwise after this hearing. What are your submissions in that?
Our submissions, there's a direct answer in Nundalal on this point, and I can't recall now where I've referenced it in my note, but it is this. He's correct that the former president has a right to approach a court and prosecute somebody criminally. There is a strong proviso. You comply with the provisions of the CPA. If the criminal charge is frivolous and vexatious, Malene Junior is looking for that. I'm sure that I did reference it. I just. He's got a right to prosecute the one that says yes, he is subject to compliance with it's paragraph 26. Okay. I'll get the paragraph in a minute. My learned friend says it's in the preamble of his heads. I just want to just be sure that I get the right paragraph. My lord, just my lady and my lords. 40, 30. Okay, yes. No, the one that refers to section 35. Sorry, my lord, my lady and my lords. The paragraph refers to section 34, if I recall correctly, and I just need to find the right paragraph. Yeah, it's paragraph 54. I just got it when you also got it. Yes, paragraph 54 is at page 4614 of the papers, of case lines. I think that's the case line number, and it says this: usually, an accused would raise a non-compliance with the jurisdictional requirements of section 106(1)(h) of the CPA as a plea to the prosecution's lack of title to prosecute. As jurisdictional prerequisites and matters of standing, non-compliance can be raised at any stage of the prosecution. The court may determine the issue of title in limine or after hearing evidence. However, a decision to deny a private prosecutor the right to prosecute should be taken cautiously, not least because it implicates the right to access to the court under Section 34 of the Constitution. If he meets all the requirements for a private prosecution under the CPA and the right to prosecute is not hit by the limitation in Section 36, the private prosecution should be allowed to proceed. Regrettably, neither party raised this vital constitutional question, but it is always, because it's a right regulated by statute, Section 7 of the CPA, unless you challenge the section as being unconstitutional, your right is limited by that section, and your right of access to court on a particular complaint depends on whether that complaint and your institution of the private prosecution complies with Section 7 of the CPA. Here we submit it's a frivolous and vexatious complaint, criminal charge. It can't the private prosecutor lacks substantial interest in pursuing it.
So you're saying the issue of interfering with his rights does not arise because it's simply non-compliance that stops him?
Yeah, so there's a lawful interference with his rights.
It's a lawful interference.
Yes, it's a justifiable interference under the Constitution because Section 7 and 9 of the CPA justifiably limits his rights to prosecute someone else. So we are not in a jurisdiction in other countries where there is no prerequisite that if the public prosecutor doesn't prosecute, as a private person, you must comply with these requirements before you can prosecute.
And without belaboring the issue, are you saying, therefore, if this court were to find in favor of the applicant in that regard, the first respondent, by complying with the requirements in the CPA, regard whether these charges or other charges, would then be free to exercise his rights to prosecute.
Quite. This interdict is limited to these facts, to this charge on these facts. So if this charge, one can ask it differently. What would be the compelling reason why the court would not interdict this private prosecution if it accepts our submission that this is not conduct that would amount to criminal conduct? Assuming the court were to accept that, then there's every reason to interdict it, because otherwise you're allowing a frivolous and vexatious prosecution of an applicant. That's the point we make. As the court pleases.
Mr. Manager, I've got a different concern regarding your prayer for the interdictory relief. And that is this being a review application. If we grant that order, are we not usurping the powers of the DPP if we uphold the following grounds of review? That the both noles were not issued in respect of the applicant and for the purported charge. Because that would entail, and this is what Advocate Zungu tells us in her answering affidavit, that she actually has not considered any charges against the applicant. I'm just concerned about judicial overreach.
Yes.
Is it not premature?
Yes.
Because there isn't any charge that has been investigated by the police against the applicant. And the DPP has not considered it.
Yes.
If we are with you on those grounds.
Yes. I accept the court's observation is spot on. In other words, if the court upholds the review on the basis that there is no nolly relating to the applicant, that doesn't mean there couldn't be a nolly relating to the applicant in future. But in relation to the same issue.
Yes.
But the former president would just have to follow the proper process.
Yeah, and I'm raising my apprehension about usurping the powers
Yes.
of the DPP, because to succeed in obtaining this relief, the applicant will have to satisfy us that he does not have. Firstly, he must satisfy us that he's got a reasonable apprehension of harm, which of course doesn't arise if the request for a nolly will serve before Ms. Zuma, right? So it's the possibility of the first respondent using these nollies to mount another prosecution.
Yes. So
Would not arise.
I understand that.
Yes, and then the second requirement that I'm not satisfied that the applicants meets is in relation to the remedy, because if Advocate Zungu does not issue another nolly, we don't know what's going to happen in that
Yes, we
office
don't.
when that request serves
Yes.
in that office. We don't know. But if she does not issue another nolly, then that's the end of the matter. There will be no private prosecution against this applicant in relation to these charges. Is that not another remedy?
But that's my ladies, all the permutations are all plausible. So I can't argue against them being plausible remedies, and I accept the court being cautious of overreaching and breaching separation of powers in this case, where the DPP says, I've not ever been presented with an opportunity to consider this kind of charge and decide whether or not to prosecute. So I accept that, and the court has a discretion in that regard not to grant the final interdict. So I wouldn't.
And you make the point in one of the grounds, well, the applicant does, that the DPP did not consult him
Yes, that's
when
the
he issued the
permit.
note. So that's another remedy.
That's another.
You can go and make your case there.
Yes. No.
When that request serves before the DPP.
My lady, I think the court has raised very proper questions around the issue of the interdict, and I accept the court will exercise its discretion. And this is in the exercise of its overriding remedial powers under Section 172B of the Constitution. It will fashion what remedy, in its view of effects, is the most appropriate. And that's what I asked for.
Another issue I'd like to debate with you
Yes.
is you're not asking for a definite ruling on this issue, but it especially when I read Nunandao, this issue bothered me. That in that case, and I think that's where you took the principle that this is a Paja review. In that case, the court raised that issue mero motu. That review didn't go there as a Paja review. It went as a Rule 53 review, right? And it's probably around the time when jurisprudence had not crystallized around, whether a review is done in terms of Paja, common law, legality.
Yes.
But now it is. It has crystallized. It's either a Paja review or a legality review. There's no longer a common law review. Why I think that question is important, and it's because of the reasoning in Nonanda, where the court, I don't have the section in front of me, but
Yes.
the court makes reference to the definition of administrative action in Paja,
Yes.
and that section excludes judicial functions,
Yes.
right, as well as the decision not to prosecute and the decision to discontinue a prosecution, right, and limits its interpretation of the prosecutorial decision. And that's my concern, because if one reads Paja purposefully, the legislature could have intended that prosecutorial decisions are not subject to review in terms of perjury. So I have difficulty with separating out a decision to issue a nolle from other
I understand.
prosecutorial decisions of the same class,
Yes.
which is the decision not to prosecute and the decision to discontinue with the prosecution.
Yes.
So it might be, I know that you don't insist on a definite finding in that regard, but it may be important to set the law straight. Because essentially, even in Noonendal, when one reads Noonendal, no grounds of review were set out. Largely, it takes more of a character of a legality review,
Yes.
rather than a perjury review.
Yes. Yes.
Similarly, here you've tried to set out what one could categorize as perjury reviews, but essentially, it is a legality review.
Yes.
Because it's about whether the applicable statutory provisions were complied with.
Quite, Justice. My lady is correct. In fact, in one of the tapes case, the DA versus the NDPP, where they were reviewing the decision to discontinue the prosecution, the issue was raised upfront in limine and went to the SCA, and the court said it doesn't matter whether it's perjury or legality, because ultimately legality will be reviewable under legality. But fortunately, we would think that for present purposes, this court doesn't have to decide whether it's perjury or legality, because ultimately you have a statute that requires compliance with before you can privately prosecute, and that's a legality standard set right there. So if you don't meet you don't comply, you're in breach of legality, and it's reviewable just on legality. So we don't want to trouble you with the case doesn't rise to the level where you now have to decide whether, for instance, whether the nolle is invalid because my client wasn't heard by the DPP. If that was very decisive in the case, maybe you would have to make that determination, but you don't have to make the determination, because there are other grounds on which we think the case can be decided than the perjury issue.
Mr. Malanche, are you abandoning your argument regarding security?
Oh, no. It's not
Because you
abandoned.
haven't addressed us on that.
Yes.
And a lot of heavy weather has been made on the papers on that aspect.
Yes.
So is that an omission that you just forgot, or you're not abandoning?
Justice Ismail, sorry, my lord, the point of security raises two issues.
Yes.
So it's common cause that security wasn't paid prior to the issuing of the summons.
It was paid in April of this year.
Was paid in April of this year, and there's a view that the full court condoned it, albeit it wasn't not in open court by way of a court order. Or let me not say not in open court, I might be wrong about that, but not by order saying that is condoned. But there's a view that it was condoned. Our submission is that the court has to deal with the issue of security within the discipline that Section 172 of the Constitution requires. So the Section 9 says you can't take out a summons without paying security. And there is no power given to condone like you would have in perjury. Now, we think there are two ways of dealing with the security issue, is uphold the invalidity of the summons because they were issued without security. In other words, the issuing of the summons was invalid, but the court has wide discretion under Section 172B to decide whether that non-compliance means the whole prosecution must be set aside or not. So you can deal with it as a remedial issue, as opposed to writing it off as if it's not a statutory requirement by saying it can be condoned at any time. We think that approach is a wrong approach. We think the right approach is the approach which Section 172 requires. In Bengwenyama and Steenkamp, it says if conduct is in breach of the law, the court is duty bound to declare it invalid. But that doesn't mean it's automatically set aside. You can still find that there's good reason why, despite it being invalid, it must be permitted to continue. I'm just putting that as the two possibilities, and we submit that there is no power to condone in the legislation. None has been pointed out. The only way we see the court dealing with that is to find, on the common cause facts, no security was issued, the summons were invalidly issued, and then it can exercise discretion under 172B. And here I'm thinking, let's assume that all I had before this court today to stop this prosecution was that security was only paid in April. You probably could say, but what is our power under Section 172B of the Constitution? That's the sense in which I'm making the submission. And I think the court is familiar with its powers under 172B.
Can a court condone non-compliance of a statutory requirement?
My understanding, and I
ask this in the context of an affidavit that isn't commissioned in terms of the Commission of Oaths and Justice of the Peace Act.
Yes.
One hears this often in motion court. No, but the court can exercise its discretion. There's an AD decision that I had to once write a judgment on. It was written by Justice Corbett.
Yes.
In the old AD, was acting judge then. And it says that if it's not commissioned properly, it is voidable. Now, applying the analogy here, if there hasn't been compliance with the statutory requirement of paying security, can a court then say, well, you didn't pay it when you ought to have paid it. You waited for several months or a year or whatever, and now you've paid it, there's substantial compliance, we condone it.
Our submission is that there is authority in the law, and I think there's an Investec case and a Toyota case of the SCA, which says that if there are only limited circumstances in which a court can condone non-compliance with the statutory provision, excluding the instances where the power is expressly conferred. And that is if the condonation is to allow for access to the court. So if a statute, if without condonation a person would be kept out of the court, the doors would not be open, there might be a power to condone. But that's in very circumscribed situations, not in a case like this. Here the statute says you can issue a summons. So access to court is wide open, but you must just pay security. And it's a good sense why that is the case. Because if you're allowed to pay 2 years down the line, the accused might have had to incur significant cost, inconvenience, all of that, and you might in the middle abandon that prosecution. And then they are exposed. And that's why the law insists on security. And we submit that there is no power to condone that is granted. There are no interest of justice considerations that would justify condonation in a circumstance like that. But we accept that under 172B of the Constitution, even an unconstitutional conduct may be allowed to stand if there is the public interest. Here you don't have public interest to justify allowing that to stand. And in instances where there are weightier grounds to set this aside, to declare that this is invalid, there's no reason to grant any condonation. The whole prosecution is invalid.
Mr. Manager, I have difficulty with considering this condonation issue from the say-so of the first respondent. I've not seen any evidence on the papers that the court in Part A condoned.
No, there is.
I've looked. I've not seen a court order. I've not seen minutes of case management meeting where this is purported to have happened. The court seems to have only issued directives regarding the filing of papers and admitted the amicus.
We have never said we accept a condonation. What happened in the Part A hearing was the court said there are lots of condonation and many other issues before the court. We're not going to trouble ourselves with that. We'll deal with the key points about the lawfulness of the prosecution, the question of jurisdiction, and that is what the court did. But it's correct that in chambers there was an inquiry about whether the former president could go ahead and pay security on the basis that this can be condoned. What I don't recall, and I can't say this, is whether the court said, yes, if you pay, or you pay by this date, or in this way, that non-compliance is
I would
condoned.
want to see
Anyway,
a
it would
court
not. It would have been in open court. It would have to be in open court, and there would have to be an order. But our submission is simply the statute doesn't allow that condonation. There's no basis to condone it in circumstances where, on all other fronts, the first respondent acted unlawfully. Where is the public interest that would justify any condonation? The interest of justice, nothing. And even under Section 172B, the overriding consideration for exercising the just and equitable remedy is the public interest, always overriding consideration. Here, the public interest is in ensuring that a private prosecution is lawful, not the other way around. So we submit, and we don't abandon that point. We abandon no point in our heads of argument. I just focused on the issues that I believed were weightier, that I needed to develop in oral argument, but we stand by our heads of argument and all the points we've made.
With regard to this question of condonation, I would submit you've been quite generous in referring to Bengwenyama and the approach that was taken there, that even if that compliance with security was not done, the court under Section 172 could go on to allow to condone. But referring to the exchange you had with my sister with reference to whether this is a perjury review or a legality review, it seems you're conceding that maybe it should be viewed more as a legality review. Would then a condonation be, by implication, as it were, in the absence of any order, as it appears, be proper in this case?
Well, you need an order with respect, yes, because if condonation, recall that the rule of law binds the judiciary also, binds the courts when they discharge their functions. So if you're faced with an objection by us saying, this statute says we can't be prosecuted without security, and that is to be condoned, that must be done properly argued, a proper basis must be laid for the condonation, and the court must find that it does have a power to condone, and condones in a judgment that we can challenge later. But absent that, with respect, there is no condonation as we speak that's effective in law. And on Bengwenyama, I take my Justice Batko's point. That's correct. Even if the framework applied, there's no public interest consideration that justifies overlooking anything here.
Yes. Yeah. And wasn't it part of your head's argument that non-compliance with one of the requirements with regard to the circuit certificates is fatal to the issuance of summons without one?
Quite, yes, that's our submission. And that's what the section says. No person shall issue without a nollie, without paying security.
So you stand by that?
We stand by that. And as I've said, in relation to the nollie, our primary submission is that the nollie is not relating to the president. To the extent that it may be interpreted to relate to the president as the applicant does, then that nollie is irrational because it could only relate to the president if the DPP had before her a charge against the president in the sworn statements. But there was no such a thing. So it would be irrational in relation to the information that was placed before the DPP. And that is only if you have to reach that point. But we submit that you don't even have to reach that point. The summons are just invalid on their face. Those are our submissions, and I will give an opportunity for my friend, Ms.
That the issues around the amicus should be dealt with at the point where the amicus is about to rise.
I see.
So because you are challenging the relevance of the amicus's submission.
So we do two things, Malay.
Yes.
Maybe that's a misunderstanding.
No,
in
that's
our,
the issue.
our
No.
response.
Let me just give direction on how the court would like to approach
Yes.
the submissions of the amicus. The court is concerned about the relevance of the submissions of the amicus. So we share your concern.
Is the court pleases.
And we would like that issue explored first, right? And in the event that we are of the view that the submissions of the amicus will not be of assistance to this court, it should end there.
Yes, the court, please.
Particularly because of the manner in which the amicus was admitted, right? So I don't want to go into those issues at this point, but at the point where Mr. Ngalwana rises, that's when we'll have that discussion. So that's when
Ms. Muvangwa.
Ms. Muvangwa
Yes.
will have the pleasure of hearing you, Ms. Muvangwa, at that point.
Yes, the court, please. Then I'm done.
Yes.
And I thank the court for the indulgence. Yes, the court, please.
Mr. Ngalwana?
Justices, perhaps this could be an opportune time to hand up a note in which we reply to our learned friends' objections. We've given them the note this morning so that they could have sufficient time to consider what we say, so that when they argue, when they address you orally, they will have to deal with the points that we raise. Perhaps over lunch you could consider.
We get to you
some
tomorrow,
issues.
right?
Yes.
We
yes,
get to you tomorrow.
we get in tomorrow, but I don't mind.
Yes,
handing
Mr.
out,
Manager, do you have an
today.
objection to
It's
this
very
document being handed up?
No, we have no objection. He's given it to us.
Okay.
Yes, the court, please.
Thank you. Thank you.
Mr. Mpofu, perhaps we should break for lunch. It's 10 to 1.
Yes, as the court pleases.
And we'll hear you after lunch.
My lady. I thought it
Oh,
was
no.
the NDPP first.
Oh yes, we hear that. Perhaps we should hear them because we're not giving them a lot of time.
Yeah.
I think we should hear them. The DPP. Yes, Mr. Muriti, there.
As it pleases the court, my lord, you will note that the approach that is adopted in the papers is not to get involved in the fray between the former president and the current president. I mean, our explanation is we are here because we've been cited as respondent number 2 and number 3, and the whole purpose of the affidavit is to set out the background that led to the issuing of both the certificates and what is it that was considered when those certificates were issued. Namely that the current president was at no stage a suspect. No docket was presented wherein the applicant is a suspect. And to the contrary is the fact that at one stage the applicant was served with indictment wherein it's indicated that he is going to be called as a witness. Then subsequently it appears he is a suspect. We say we do not want to enter that fray. It's between the former president and the current president. And you will note that there are somewhere in the amicus affidavit wherein allegations are being made that it appears the second and third respondent are protecting the applicant. We respectfully submit that there is no merit in that. It's only speculation which is not supported by any factual evidence. The function of the second and the third respondent are that they owe their allegiance to the Constitution and not to the current president. So on those bases, we respectfully submit that those are merely vexatious, malicious, and spurious allegations being leveled against the second and third respondent. That's our argument.
Anything further?
Nothing.
We've noted the prayer you seek is consistent with the prayer that the applicant seeks in relation to the invalidation and setting aside of the knowledge, only to the extent they apply to the
The finding
applicant.
is made that they apply to the
To
first
the-
applicant.
To the applicant. There's only one applicant. Right? To
That's-
the applicant. Yes.
That's correct.
Shouldn't have used state attorney. You haven't taken a position as to whether the state attorneys are, if I could use the term, it's my term, the state attorneys shouldn't have been used and that the applicant should have used his own attorneys.
As I indicated, it's one of those points that we do not want to entertain. It's not our domain. It's between the applicant and the former president. And that demonstrates that, second and third respondent are independent.
Thank you.
Thank you, Mr. Mutibedi. Perhaps we should hear Mr. Mpofu at this point.
My lady and my lords, I just wanted clarification on the ambit of what the NDPP seeks. My understanding was that they sought the invalidation on the basis of lapsing of the certificate of the 6th only. But from the summary that was given by the court, it seems as if it goes further than that. For the rest, they applied. That's how I understood their case.
What we're indicating, we say the certificate, the first certificate,
Yes.
it has lapsed.
Yes.
Yeah.
Reliance cannot be placed on that, and it's not even necessary for the court to make a finding on that because it's moot.
The June certificate.
That's correct.
Thank you, Mal.
So you're qualifying.
That's correct.
Yes. You've qualified the order in relation to the second certificate,
Yes.
right? Only to the extent it applies. to
That's correct.
Thank you for
No, thank you.
extracting that clarification.
Yes, no, I was worried that the
Mr.
case is growing before our eyes. Thank you.
Thank you, Mr. Mutibedi. So our estimation of the time allocated to you was spot on.
Court and grant.
We adjourn for lunch. How long? An hour? An hour. We'll be back in court at 2.
He's a boom.
Yes, Mr.
Thank you, my lady. My lords and my lady, just a slight change of plan. My original plan was I was going to do a bit of landscaping or signposting and deal with one of the points in limine. And then my learned friend, Mr. Muela, is going to deal with the question of jurisdiction. So, but I think just for efficiency, I'd rather have him deal with jurisdiction, even if it's a bit out of order, because we would have wanted to deal with locus standi first, so that when I come, I then deal with everything else. If that pleases the court.
That's fine.
That's fine.
Yeah.
As court pleases. Therefore, Mr. Muela will deal specifically with the issue of jurisdiction. I will deal with locus standi and prematurity. But there's an overlap, obviously, between jurisdiction and prematurity, so I won't repeat whatever he has done. Thank you.
As the court please, my lady and my lord, I'm going to briefly deal with the issue of jurisdiction, and my learned colleague will take it from there, where it overlaps to issue of prematurity. But before I start, I need just to emphasize this, that I agree with your leadership sentiments that the issue of jurisdiction should never just be overly simplified, as it happened in part A of this application, and there was an attempt again to oversimplify it. I'm going to try to assist the court about the gist in respect of jurisdiction. So primarily, this case is a typical example of what is called in our law preliminary litigation. It happened in an instance wherein an accused person would have been charged in a criminal court and would come in a civil court like we are sitting today and raise a plethora of objections that result in a criminal trial being delayed. And that's what happened here. On the 19th of January, the criminal trial was postponed because of this matter. It's sitting again on the 26th of May, likely to be postponed if the judgment is still reserved. And my lord, that is very important, because in the legal philosophy that I'm going to deal with in respect of preliminary litigation, it will show that you don't just shift your matter from a criminal court and you bring it in a civil court and you say that because my notice of motion says that this is perjury, because my notice of motion says this is abuse of process, because my notice of motion says Mr. Zuma would like a title to prosecute, therefore this court has jurisdiction. That's not how easy it is. There is a hurdle that you need to pass. First of all, our case law tells us that preliminary litigations should be disallowed. This is one. Should not be countenanced and should not be permitted. And when I say our case law, I start from the highest court in the land, that is the Constitutional Court case. We also have jurisprudence in the SCA, my learned colleague referred to that. We also have many others that were omitted. The case of Mikesi, I'm going to address it. It was omitted, it doesn't favor them. The case of SITA, it was omitted, it doesn't favor them. Actually, it is very fatal. The case of NEDCO, it was relied skillfully, but ultimately I'm going to show that even the case of NEDCO does not favor them. May I please start with this excursion now from the Constitutional Court case, just to lay a judicial basis in respect of this topic about criminal litigation. The first case in point that I'm going to rely on is the case of Tint. The case of Tint, we relied in paragraph 70 of our heads of arguments. The case line kept on changing the numbers. So I'll start by referring to a paragraph in our heads of arguments. The new case is 011-317. That is a passage from Tint. And I'll just read this. It's a short passage. It falls in those three categories that I mentioned. It should not be countenanced, should be disallowed, should not be permitted. It says that generally, disallowing such preliminary litigation, we've inserted the word preliminary because they were dealing with the preliminary in the preceding paragraphs. Generally, disallowing such preliminary litigation would ensure that trial court decides the pertinent issues, which is best placed to do, and will ensure that the trial starts sooner rather than later. There can be no absolute rule in this regard. The court's doors should never be completely closed to litigants. But in the ordinary course of events, and where the purpose of litigation appears merely to be the avoidance of the application of Section 35, subsection 5, or the delay of the criminal proceedings, all courts should not entertain it. No special court that need to give this particular litigation any preference. The trial court will then step in and consider together the pertinent interest of all concerned. I must also add, in terms of Section 35, the avoidance of Section 35, there's also an avoidance of Section 106, of which my learned senior will address in great detail. So they are avoiding not only Section 35, because they speak about whether their right to a fair trial would be guaranteed, if I were to use that word. Section 106, we had the discussion why it was not used. It was not convincing. I simply say that it's not the only mechanism to challenge the title to prosecute. Then I'll then go to this case of Moyo now. The Supreme Court of Appeal. We rely in our heads of argument three paragraphs. Paragraph 67, paragraph 68, and paragraph 69 in our heads of arguments. And it starts on page 011-316. My lady and my lords, I will not necessarily be reading citation. The citations are there in the footnote and stuff. I'll just refer to as Moyo in the SCA. So this is how it reads. The appellants do not seek to impugn the provisions of the CPA in any way, yet they are seeking to assert their fair trial rights before a civil court, which is this one. That should give pause for thought. Why are issues germane only in the context of criminal proceedings being canvassed and determined in civil proceedings, and not in the constitutionally compliant forum? And that's the question that your ladyship was asking. That surely there is a distinction between these two forums. And there's a reason why certain matters need to be dealt in a particular forum. Your ladyship also highlighted the issue of procedures. There are certain procedures that need to be followed in one forum. There's certain procedures that need to be followed in another forum. As it continues, and in accordance with the constitutionally compliant statute provided for in the adjudication of criminal proceedings. In this instance, the statute that is provided for is the Criminal Procedure Act. And in any event, that's their understanding. Because if you really look at their pleadings, not at their conclusion, if you really look at their pleadings, what they're seeking to achieve, it's merely to challenge the title to prosecute. They might cloth it and call it an abuse of court process, they might cloth it and mention a lot of things. But in their own words, they say that the abuse of process will amount to a disentitlement of Mr. Zuma to prosecute the current president, Matamela, Ramaphosa. That's what they seek to achieve, nothing else. Because they understand that they cannot just come to court and want to interrupt the criminal proceedings on a mere allegation of abuse of process. It will not assist them. That's why in their papers they say, no, but that's not the only thing that we are relying on. We rely on a lot of things. But that's a dominant factor. And it's a mere allegation. I'm using that deliberately. It's a mere allegation of abuse of process, of which normally it should be done in a criminal trial. They must raise it there in a trial. If there's going to be an abuse, they will be discharged in terms of Section 174 in that forum. And that particular point will also be addressed by Melanie Senior. In other paragraphs that follows, I'll just read two of them in tandem so that I then make my submission, so that to limit the time. The next paragraph is paragraph 68. It's also a quotation, direct quotation from the case of Moyo as well. It is commonplace to see in the media that the first step in any criminal litigation involving a prominent person. I want to pause there. Can't dispute that the applicant is a prominent person. He is the president. He brought himself here as a president to challenge or to raise plethora of objection in order to avoid a criminal trial. Involving a prominent person is that they will challenge the constitutionality of the charge. That's what they did. They're challenging the constitutionality of the charge under Paja, or the process leading up to the commencement of the proceedings. The summons were defective and all that. They're doing exactly what the case of Moyo is talking about. The term Stalingrad, I know it from the former president. The term Stalingrad defense has become a term of art in armory of criminal defense lawyers. By allowing criminal trials to be postponed pending approaches to the civil courts, justice is delayed and the speedy trials for which the Constitution provides does not take place. One would even think that I'm reading the affidavit of Mr. Zuma. No, I'm reading the case law. This is the law. It seems like this is what we would have said in our papers. I need hardly add that this is of particular benefit to those who are well-resourced and able to secure their best lawyers. Not only, at least it's public knowledge, that the applicant is a rich person, at least he's well-resourced. But not only is he bringing his power, his resources, he's also using the state resources to defend his interest. So that is a typical example of a pre-litigation that should not be countenanced. If one would make an example in terms of level, this is a level 6, if we were to compare it with the issue of load shedding. It's the highest level of load shedding. It's the highest level of preliminary litigation. Then the last part, this one I will not make any comments because it concludes all these paragraphs that I started with. That is in paragraph 70. It says that, and this is what my learned colleague quoted, generally disallowing, I apologize, my lady, I think I'm reading the same paragraph I'm looking for.
Looking for the third paragraph in Moyo.
I apologize, my lady, because of my nose bit away. Yeah, I found it. It's paragraph 69.
Yes.
This is the passage by Justice Wallis. As a general rule, departures from the procedures laid in the Criminal Procedure Act and all effective removal of criminal proceedings to civil courts should not be countenanced. And that's why I'm using it as a conclusion, because I'll repeat myself. Started with it, I'm exiting with it. I'm exiting with it in respect of that point. Then, this case was following the principle or what was discussed in Tint as the Constitutional Court. Now, I also spoke about over and above these two courts that have spoken in strongest terms against the approach of preliminary litigation. There is the important case of Mukesi, S versus Mukesi, we cited that in our heads. That is paragraph 93 of our heads. And what this shows us is that indeed this principle that were espoused in these two cases are binding. From the Constitutional Court, from the Supreme, now it's even applied. And it's the most recent, is the 2022 judgment. This is what it says in paragraph 93 of our heads. So in the case law itself, we relied on two paragraphs, paragraph 43 and paragraph 44. But we also quoted them word verbatim. And if there's going to be any long passage that I'm going to read, this must be one of those passages that I must read. It says that against this sketch of the legal position, I tend to examine the relief sought by the applicants in this matter. The hallmark of all four applications is that the accused have not yet pleaded to the charges against them. There's a plethora of accused. Yet each seeks declaratory orders without any evidence being laid against any of them. They have given no indication, this I highlighted, they have given no indication of why these challenges in respect of the charges and the evidence to be presented are being brought before this court, and not the court that will hear the trial, which is, to use the words of the Moyo, the constitutionally compliant forum. Each appears to have simply ignored the provision of Section 85 and other relevant provision of the Criminal Procedure Act. I've already mentioned that they are avoiding Section 106, Section 85, Section 87, which is the constitutionally compliant statute promulgated specifically to deal with all aspects. And exiting that, in paragraph 44, the court has a discretion to grant declaratory orders after due consideration of all relevant circumstances. One of the factors to be considered is whether the issue raised before it is hypothetical, abstract, or academic. If the answer to that is in the affirmative, the court will decline to grant a declaratory order. It is not the court's function to give legal opinions or pronouncement or make pronouncement on abstract and academic issues or questions. This, then the highlighted part, because they then refer to case law. My view is that the test is applicable in civil matters and not in a matter such as this, which falls into the category of preliminary litigation relating to criminal proceedings. The latter is regulated by the CPA, the Criminal Trial Court being the correct forum to decide the issues in respect of the declaratory order sought in this matter. You remember, your lady, they also say that if indeed we are failing on the issue of title to prosecute, but we have other reliefs that we are seeking, therefore this court has jurisdiction. And with utmost respect, my lady and my lords, that is incorrect. We can take them to the case of NEDCO. It answered that question. In fact, that's what, in our heads, we even say that their prayers substantially mimics what was prayed for in NEDCO. And NEDCO categorized those 5 prayers and refused to deal with the issue that should be raised under Section 106. And you'll find the passage, just that when the presentation was made, there was selective reading of those paragraphs. Because if you read all of it, it will give you the picture. That is paragraph 89 of our heads. In the new case line, it's in the new case line generated number 011-323. It's the case of NEDCO Bank versus Kwelichana and others. And it starts by saying that the applicants contend that the institution of private prosecution is irregular, vexatious, and abuse of court process. That's a theme. That is their theme. And it says that inter alia, then they add other ingredients, of which the same ingredients were added here. After starting by saying that it's an abuse of court process, Mr. Zuma does not want me to be the president. Mr. Zuma wants me to have the step-aside rule applied to me. It says that the first respondent lacks the title lacks the requisite locus standi to proceed. The summons commencing the proceedings invalid for want of compliance with Section 10. They raise a lot of non-compliance. There is no prospect on the first respondent's own version of events of any court convicting the applicants. That's what they say. They even say it's not even a criminal. Someone cannot even be criminally charged. They take it further. 4.4, the institution of the private prosecution is actuated by mala fides on the part of the first respondent and or his representative. The prosecution was initiated with an ulterior motive to oppress and harass the applicants rather than to secure criminal trial. Then what is important is what follows. Because after enumerating those prayers in NETCO, they severed some of the prayers, of which we are also asking this court to sever such prayers as it was in NETCO, and not on merely simplifying the issue of jurisdiction, because that was important for NETCO. NETCO is influenced by the correct position in law in respect of preliminary litigation. I don't want to talk about a case of 1950. My learned senior will deal with that extensively. It says that the points taken in subparagraph 1, 2, 3. 1, 2, 3, if the court is following, is requisite of locus standi, invalid summons for lack of compliance, and then the other one, prospect of success in the prosecution. Those are the three. Title to prosecute. The points taken in those paragraphs that I've mentioned relate to the merits of the prosecution. It must be clearly stated, however, at the outset of this court, at the outset, that this court does not have the power to usurp the functions of the magistrate. For example, the challenge to prosecute, the challenge to the prosecutor's title should properly be raised in the magistrate court by way of a plea. At that time, the matter was seized in the magistrate, but it makes no difference. In this instance, it's seized in a criminal court. That's important. And they say it should properly be raised in that forum. And it was not entertained. It was not entertained. So, to the extent that in those 3 prayers, 5 prayers, if I'm correct, the court lacked jurisdiction to entertain the first 3. On the basis that this is not just a mere simplistic distinction of a civil court and a criminal court. It's very important in our law. In respect of the ones that at least they survived, we say that that means that would be the only thing that they are bringing this case relying on an ulterior motive. And we know that that's not sufficient. That is not sufficient to rely on ulterior purpose to frustrate the commencement or the continuation of a criminal trial. Because if you eliminate other things that they are trying to convolute, then they are left with a standing alone abuse of court process. And it does not assist them that much, because it ended in the speculation. Speculation of saying that prosecution was calculated at me not running for the president. He is still the president, the proceedings have commenced. Have commenced by issuing the summons. The proceedings have not been interdicted. It is Mr. Zuma who is interdicted. So it's still running. So if indeed it was calculated that he would not be the president when we wake up the following day, but he is still the president. So that means now, even on these facts, the issue of abuse of court process calculated at achieving certain ends, it cannot be proven. Outside the fact that it's a speculation, it cannot be proven on these particular facts. And there is at least one case law that supports this proposition, that actually an abuse of court process is challenging the title to prosecute. So that means all those 5 prayers, if the court accepts that proposition from this case law that I'm about to make reference, that means all of those prayers are dead. Remember, the first 3 are dead because of jurisdiction. this one they're still hanging, but I'm saying that in terms of this case law, if the court is with me or with us, then the entire case is dead. This court lacks jurisdiction. It does not matter the merit. Now we agree. That's a clear position in law, that when you are determining the issue of jurisdiction, you are not concerned with the merits. In fact, they invest more on the merit. They invest so much on the merit. This is not a charge, this cannot happen. All this because from the inception, they don't have the strongest point to enter this court. But they want to exit victorious. Paragraph 92 of our heads, we mentioned this case law, that I'm saying that it held that an ulterior purpose falls under the ambit of section 106(1)(h) of the Criminal Procedure Act. You will find that on page 011-325. That is the case of S versus Musa. And I'm just going to... That is the case of S versus Musa. It's there on paragraph 92. I'm just struggling to source. Sometimes the internet is slow, but I'd open it. But the proposition is this, is that the ulterior purpose can also result in the lack of title to prosecute. And that's also their understanding from their own affidavit. The passage has been provided, my lady and my lords. And it says that, I'm going to read the part, that important part. If such a person institute a prosecution for an ulterior purpose that will constitute an abuse of process, which will affect the title to prosecute within the meaning of section 106(h), the same would apply to a private prosecutor that never complied with the criteria of section 7 in the first place. So it draws no distinction. Draws no distinction. And it is a decision of this division. Then I was about to make this point that it seems to be also their understanding that this abuse of process will ultimately lead to disentitling him of prosecution. And they make that proposition first, or that understanding. I won't read this, but for the purpose of noting it down. First, they mention it in the affidavit and also in their heads. In their affidavit, first in part A, in paragraph 20, they speak about the main point of this application, the main point, title to prosecute. They repeat that sentiment in paragraph 13. I will not read those assertions. Then in paragraph 91 of their heads, this is their understanding. Our courts have held that although motive is irrelevant in the case of public prosecution, ulterior purpose is relevant to determine the prosecutor's title to prosecute. In their own words, from the affidavit under oath and even legal submission, speaking about title to prosecute, flowing from ulterior purpose or abuse to process. Then there is one case in respect of when I'm about to wrap up the issue of jurisdiction that says that you are not guided, and I started with that proposition, you are not guided by the notice of motion. You look at the character of the proceedings. Where did these proceedings commence? It will determine the issue of forum. The proceedings commence in a criminal court through the issuing of summons in December and amounted into what we are faced with now, preliminary litigation, because we are here now in a civil court trying to determine these matters that should be raised in that court. We find that case in paragraph 76 of our heads. That is the case of Sita and another versus Olivier. Full citation is there. So it tells us that when you have to determine the issue of jurisdiction and forum, at least under the preliminary litigation context, you have to look at where the matter emanates for you to determine, because it will tell you the characters. It will tell you the character of the matter.
Where's the authority for that proposition?
It's Sita is the one that I'm about to read. I was just giving a preamble to that. Yes, thank you, my lady. It's the one that I was about. That was just a preamble. May I please quickly kindly read it? Yes. It says that it's in paragraph 76 of our head, my lady. And that is page 011-320.
Paragraph 78?
76 of our heads of the first respondent heads of arguments. That is 011-320. New case reference. May I proceed, my lady?
Yes.
Oh, sorry for the mere fact that proceedings in the court ACOA were fresh proceedings instituted by way of notice of motion does not give to those proceedings the character of a civil nature, of a civil matter. Then it says that in terms of Rule 53 of all proceedings, in terms of Rule 53, all proceedings to bring under review the decision of proceedings, whether civil or criminal, of any inferior court must be by way of a notice of motion. Such proceedings are always fresh proceedings, but it cannot possibly be contended that ordinary proceedings to bring under review criminal proceedings in an inferior court after conviction and sentence on any other grounds mentioned in Section 24 of the Supreme Court of Appeal constitute a civil matter which originated in that court. And then this is the most important phrase. We bolded it. It is, in my view, not the form of procedure adopted, but the subject matter of the proceedings which determine the character as either civil or criminal. So it's not about them saying that we are relying on Paja. This court hears matter on the basis of Paja. We look at the character itself and where the matter originated. In concluding this point, it goes further. What is relevant to the question seems to be the forum in which the subject matter in dispute in the subsequent proceedings first arose. That's the point that I was making. First arose in the criminal proceedings, and it's here in the civil court. Now, in my view, does the fact that the relief was sought by way of a declaratory order, interdict, mandamus, made the proceedings before the court acquire a civil matter originating in that matter? So it does not matter whether you are seeking an interdict, does not matter whether you are seeking all sort of objections, but it falls under preliminary litigation. The principle does not say that if you are bringing it under these auspices, then preliminary litigation is allowed under this. In fact, the starting point, we started by saying that is a general principle. So how do you exit that? They say that the case of Moyo established a principle that it is the interest of justice. That was not the test that was established, the interest of justice in terms of avoiding the general principle. The case of Moyo was faced with the constitutional challenge that of a case that has been running for years. And in fact, before they even said that in this case, at least in the interest of justice, not as a principle, in this case, we wanted to take the matter back to High Court. They wanted to take the matter back to High Court, but they look at other considerations, the delays. It will even defeat the purpose of what it should not be countenanced in preliminary litigation. The matter would have been delayed. This matter, if the applicant had subjected himself to the criminal trial, the matter would have proceeded. Perhaps he would have raised all these points that he's raising. There's not any exceptional circumstances why this court should intervene. When the reliance on Moyo is misplaced, Because in Moyo, on the facts of Moyo, if there was no delay at least, it was going to be taken back to the High Court, to the criminal court. In fact, one of the discussion in Moyo was this. The party that brought the matter to the civil court, they said that, but the magistrate does not have competence to deal on the constitutionality. He said, but you could have taken the matter from the magistrate court and bring it in the High Court, in the criminal court. They didn't just say take it to the High Court, to any court. Take it from the criminal court in the magistrate, take it to the criminal court in the High Court. That's what it says. So the interest of justice is some invention. It's not the principle that was established. The principle that we know, and it says generally that attitude should not be countenanced. So that means there must be exceptional circumstances, and none have been pleaded in this instance. Even the abuse of process, my lady, does not assist them. May I please kindly ask if...
Which judgment establishes the exceptional circumstances principle?
My lady, my learned senior would will continue with it, my lady, so that we can be economical with time, as the court pleases. Even the questions, my lady, unless otherwise there's a specific question that I need to address.
What would really assist is if you addressed, you heard Mr. Manaj, so I wouldn't want to start itemizing his submissions and asking you questions along those lines. So what would really assist the court is if you were to respond to his submissions. Because what you've simply done is to address the first respondent's case, but it would assist us if you deal with his submissions.
My learned senior would also deal with that, my lady, because this is the agreement that we just whispered now, as the court pleases.
Before you stand down, if you are about to, I get your point about preliminary legislation. Litigation, sorry. Thank you. And you referred to the Tint decision, in which, paraphrased, it says that preliminary litigation should not be permitted, as the trial court would decide pertinent issues. But in that same quotation, it is stated that this is not an absolute rule, and that courts should keep their doors open. Now, clearly, the question is, whilst accepting that, there's other case law and reference has been made to NEDCO, which you have dealt with, to Solomon, to Van Deventer, and that kind of case law. So, would we agree that the applicants are not necessarily precluded from going the other route, other than going through the criminal court through 106H? Can we agree or disagree on that point? They are not precluded. They can go the route that you suggest in your submissions, but they're also entitled to go the other route, and by that, such as we have here. In other words, they are not wrong to do so. And of course, enveloped in that is that this court does have jurisdiction in that sense.
My Lord, with utmost respect, if we start from the proposition of saying that this preliminary litigation, they are not allowed. This is a starting point. They are not allowed. It's not a blanket approach. That's the entry point.
Without interrupting you, Mr. Wela, your submission that they are not allowed ignores the other cases that are referred to. It's like they don't exist.
My Lord, even in the question that your Lordship posed, started from what Tim said. They are not allowed and then qualified. So the question should be answered in the affirmative. They are not allowed. Then in the qualification, that's the point that I was going to pass my baton to my learned senior, so that he can continue with the flow. Is the issue that I had started when your leadership asked. That the test that they said, it's not the interest of justice, it's just that in that case, they applied looking at the facts of that case. But we submit that that can only be done under exceptional circumstances. Because you have to, if there's a general principle, you can't just ignore that. And all these cases say it in strong words. So I cannot stand here and saying that they have jurisdiction. And that's why I started by saying that this issue of jurisdiction is not as simple as it's presented to be. It needs some intellectual and philosophical engagement so that when you deal with these cases, you deal with them chronologically, starting point, they're not allowed. Then we deal with other circumstances.
Yes, maybe not to belabor the point, exceptional circumstances being?
It's for them. It's for them to answer.
First answer to that, my lord, it's for them to accept that. It's not for the court to assist them. But in other instances, they've said that if you want to extort money, financial gain, then you lack the title to prosecute, which would amount to an abuse of court process. That's one of the examples that appears in the case law. And in fact, they said it must be the clearest case. It must be the clearest case, even from the case of Solomon, and of which I don't want to deal with it, and my learned senior repeats. They speak about only in the clearest cases.
Yeah. And lastly, extortion would be an illegality. So can't we say exceptional circumstances such as illegalities would constitute exceptional circumstances?
Not necessarily, my lord, because a person with good intentions can start a private prosecution, but along the way, then perhaps the other party is willing to settle and stuff like that, and if they are failing in their ways to settle, maybe in terms of the amount that they want to settle, they say, I will proceed. It's either you give me this in the settlement that we are trying to settle this matter, because they are allowed parties to at least, to then the prosecutor might withdraw the case. But if it's persisting for the purpose of extorting or for financial gain, that will be a clear abuse of court process. Not necessarily putting it as a blanket approach and we say any illegality, because now they'll get a pathway that, but that's exactly that we're relying on. Preliminary litigation. As the court pleases.
We'll leave it at that.
Thank you, Mr. Mwela. Thank you, my lady and my lords. I think on the issue of jurisdiction, I really will not belabor the point. Maybe what I will do is just to respond to two issues raised by the bench. The first being the question that was raised now by Justice Bakwa, and the second being the leadership's question about responding specifically to some of Mr. Maineche's points. But I will do so to kill two birds with one stone in the context of the prematurity point. And I'm starting with that point because it obviously dovetails with the jurisdiction point. In fact, in a way, they are two sides of the same coin. And let me first explain exactly that point, how the 2 points dovetail. We say that the applicant is in the wrong court for two separate reasons. The first being what my learned friend eloquently put out, in other words, literally the question of the forum. We are just in the wrong forum. But there's a more nuanced reason why they should not be here, which is the issue of prematurity. In other words, that even, and for that proposition, assume for a minute they were in the right court. Assume this was a criminal court and everyone was wearing red robes and so on.
And by the way, I'll come to the issue of red robes. We are saying that even if this was the criminal court, it's premature because the statute that governs this type of proceedings says when the issue of title to prosecute should be raised. And it's very simple. Section 106 says it must be raised when the plea stage is reached. Has that stage been reached now? No. So we are in the wrong court for that second reason, because it's premature in any event, even if we were in the right court. And that's what my learned friend is talking about. When you say you ignore, I think one of the cases, I don't remember which one, it talks about ignoring the statutorily provided route of raising the issue of title to prosecute, or ignoring Section 35, or avoiding it. It doesn't matter really which word one uses. The point is that you bypass the constitutionally ordained statute. Now let me come to Justice Bakwa's question. One cannot say that there is jurisdiction because it's allowed. Then one is reading away what the words say in tint at paragraph 70 of our heads. Generally disallowing. It doesn't say anything less than that. Disallowing preliminary litigation would ensure that the trial court decides the pertinent issues which it is best placed to do. And then further down, it says, or delay criminal proceedings. All courts should not entertain it. It's not ambiguous. It's disallow, don't entertain, don't countenance, as they say in Moyo. But of course, all lawyers know that there are no such things as irrefrangible rules. So it then says, of course, you can't close the door of the court forever. There will be exceptional circumstances. When a lawyer says generally, that's a flashlight. It means there are exceptions. That's all it means. But disallowed, it's disallowed. Let's not shy away from that. So that's really the submissions that Mr. Muela was trying to make on that issue. Don't countenance, don't entertain, disallow. How can it be stronger than that? Those are the words used by the SCA and the Constitutional Court, which is binding on this court. Right, now let's move to the really what is the nub of the 106 point. I'm sorry.
Before you depart from that point,
yes.
Mr. Bofu, what I tried to get from Mr. Muela was, whilst accepting the submissions that you make about tint, what I was trying to get is the same reference refers to, this is not an absolute rule.
Absolutely.
And it says, and I think you repeated that, the doors of the court should not be closed. And I suggest to him and ask, then what, in your view, are the exceptional circumstances that would allow people such as the applicants to depart?
Yes. No. Thank you. No. Thank you, Justice Bakwa. That's a fair question. Well, Mr. Muela answered it in a way, maybe in his own style. But he's 100% right. That is not a question that should be posed to us. If indeed we agree that the doors of the court are closed, right? Except if you have the key. Who's supposed to bring the key? It's them, not us. They are supposed to then assert such exceptional circumstances, whatever it is, that would make any court to depart from the general rule that is clearly set. The general rule is clear, but now it can't be the burden of the first respondent to say, okay, the door is closed, but I'll also give you a key so that you can open it. No. The door is closed. Full stop. If they want to open it, they must assert exceptional circumstances. That's the law. Now,
And the authority is tint? Did you say
tint,
it's tint?
yes, tint. Tint, both tint, incidentally, tint, both tint and Moyo, at paragraph 69 and 70, use exactly the same opening words, general, as I've explained. Moyo says, as a general rule, departures from the procedures laid down in the CPA and the effective removal of criminal proceedings to the civil courts should not be countenanced. Full stop. As a general rule. Tint says, general, again it shows you what the law is. The fact that there might be exceptions is another point. Tint also says, generally, disallowing litigation would ensure that the trial court decides the pertinent issues and so on. So both courts which are binding to this court have made it plain what the general rule is. If anybody wants this court to depart from the general rule, they are free to say so. So far, nobody has told you anything about why you should depart from the general rule. Now, the issue then becomes this, and I was coming to the issue, the real nub of the issue that Justice Modiba raised about the 106 point. Whether you're looking at it from a point of jurisdiction or prematurity, but it's the section 106 point. And her ladyship is quite correct that the real issue is whether 106 is just a nice thing to do, or it is what the law prescribes in these situations. As in NETCO, and my learned friend, Mr. Muela said skillfully, but my learned friend says NETCO says you can go into section 106 process for a title to prosecute. No, it doesn't say that. It specifically does not say that. It says you should.
I actually have it in front of me.
Yes, that's NETCO.
No, I've got the section.
Yes.
106. I've got it.
106. No, I'll come to that. I'm going to come to the specific section. I'm going to come
out on the wording.
Yes,
there,
absolutely.
And
No. We're getting there. I know that's I'm simply making the following proposition for now. That nobody must leave this room with the idea that the NETCO case says that you can take the route of section 106. The NETCO case says specifically that that's what you should do. I think it's paragraph 27. Sorry. All right. Let's find NETCO. I'll come to that. I'm trying to save time.
Paragraph?
25 and 20. All right. You can, for now, take my word for it that the NETCO uses the word should go to section 106. And it is for that reason that NETCO dismissed, all right? So let's not again beat about the bush. Dismissed the prayers based on title to prosecute. Because it said, no, you are in the wrong place. You should go to the magistrate or to the criminal court. Goodbye. That's what happened. That case was following on Moyo. It was following on Tint. Most recently, the case of S versus Mukhesi that was referred to. Mr. Mukhesi, incidentally, is somebody that I know. This is the case of the Ismahashule asbestos prosecution. Accused number one just happened to be Mr. Mukhesi, whom I represented at the Zondo Commission. Mr. Mukhesi went to the court in Bloemfontein and said, no, you can't do this because there'll be self-incrimination, because the same evidence is the same one that has been raised in the Zondo Commission, and so on and so on. And the court said, no. Moyo, tint, goodbye. And that's what happened. They said, you may have you may have your grounds and what have you. And that court, fortunately, and Netco, I think, is a bit, it's on point, but at least it didn't refer to the binding authorities. Mukhesi, on the other hand, referred directly to Tint and to Moyo and said, you can't.
But Mr. Mpofu.
Yes. Yeah. Oh, I'm sorry, madam. I'm very sorry. Just so that we get this out of the way. The reference in Netco is paragraph 26.
Yes, because I was looking at 25. And
yes, sorry. It's paragraph 20. I was misled. It says, yeah, the relevant part is, for example, oh, yes. No, let's go even further, because it also covers the issue, I think, that was raised by one of the justices about what is jurisdiction. No, it was Mr. Manechi. Jurisdiction is the power to do something, and this court uses those words.
You should have dealt with my point, because you are moving to another issue, and I'm concerned that...
Okay, well, it's paragraph 26 that I was just giving the reference. Paragraph 26 says, for example, the challenge to the prosecutor's title should be raised in the magistrate court by way of a plea in terms of section 106(1)(h), which, and then I was going to go to section 106, but it's fine, my lady. Let's...
Mukhesi.
Yes.
If you look at the reasoning of the court in Mukhesi,
yeah,
that court does not confirm the purported hard and fast rule against preliminary litigation. The court looked at the substance of the challenge, right?
Yeah.
And categorized it as an abstract challenge, because what the applicants in Mukhesi sought to do was to preempt the evidence that the prosecution is going to lead in that case and object to it before even it's led, on the basis that it amounts to self-incrimination because it was used in a narrow forum. There was a second ground.
Yes. Yeah, but those kinds
it's
of
abstract challenge,
yes,
right? So the court looked at it. It dealt with the challenge, and it said, no, it's premature. I can't be listening to you and dismissing charges on the basis of evidence I don't even know it's going to be led at the trial. So if you want to object to the evidence, go and object to the evidence in the trial. Right. So the court applied the rule, the rule against preliminary litigation with specific reference to the nature of the challenge in that case. And that should really be the approach.
Yes,
if one looks at the totality of the cases relied upon by the applicant,
yes, my lady,
as well as the first respondent.
My lady, of course, every case is different from another case. I'm saying, that's exactly what I'm saying. You have to look at it in view of the nature of the challenge.
Yes.
What is the nature of the challenge? Mr. Mwela read it out to you from the heads of the other side, where they say the nature of the challenge is titled to prosecute. Right? That's them, not us. They say the nature. Justice Sutherland, paragraph 9 of his judgment, says the nub of this matter is titled to prosecute. We agree. We agree with them, we agree with Justice Sutherland. So that's the nature of the challenge, right? Now, and we say because of that nature of the challenge, it falls under section 106(1)(h) of the CPA, right? This thing called title to prosecute, my lady, what is it?
Perhaps
Where's
that's a
the
good
other?
point for us to go to the wording
Absolutely.
of that
Absolutely.
provision. 'cause
That's where
I'd
we're
like
going.
to hear you out on.
That's where we're going. Yes. And I think it was their paragraph 90 that Mr. Muela read out, just to round off this point. Remember, my lady, that even when they talk about ulterior motive, they say ulterior motive which leads to lack of title to prosecute. So all roads lead to title to prosecute, which brings us squarely into 106. And let's go to 106. Now, the first proposition I want to make is that the phrase title to prosecute is not an invention of my learned friend Mr. Maineche or me or anybody. It's an invention of Parliament. And the only place you're going to find that phrase in the entire body of law of South Africa is in 106(1)H. Right? So let's be clear about that. Title, if it's true that there are cases about title to prosecute, where do you go? If you Google title to prosecute in all the law of South Africa, it's going to take you here, 106(1)H. It says, when an accused pleads to a charge, he may plead H, that the prosecutor has no title to prosecute. That's exactly what they are doing. They are saying that the prosecutor has no title to prosecute. But they can't do that now. They can do it when an accused pleads to a charge, which then deals with both Mr. Muela's point and mine. That the when pleads to a charge, where is that done? It's never done here in the civil court. It's in the criminal court. Secondly, when they plead, it's not now. Even if this was the criminal court, they couldn't raise it now because it can only be done when you plead. Simple. Now, the issue that 106(1)H is discretionary is, with the greatest respect, wrong. Because it's I don't know how to call it. It's an illusion of reading the section because there's a word may there. So whenever you see the word may, normally as lawyers we think discretion. No. There's no discretion. There's no accused who has the discretion whether to plead or not to plead. All the may there refers to the 9 things. So when an accused pleads to a charge, he may plead guilty or not guilty, or he has already been acquitted, there's no jurisdiction, blah, blah, blah. That's what the may talks about. There's no option not to plead. In fact, the Criminal Procedure Act says that if you don't plead, the court will enter a plea of not guilty for you.
So
Justice Ismail will know that.
The interpretation that you prefer is that the options an accused person has relates to the different pleas that are set out in 106(H).
No. It's not the option.
Did you hear me? Listen,
Yes.
I'm with you. I'm
Yes.
trying to understand your argument, right? So you are saying the election that 106 gives an accused person is in relation to the different pleas that are itemized in 106(1).
Yes,
right?
but
So it's not about choice of forum.
absolutely.
So he must go to that court and then he may plead either one or any of the others up to H.
Correct.
Is that?
That's the submission. Now, I was just saying it's not the option that I prefer. It's what it says here. It's when an accused. Well, it doesn't if an accused. When an accused pleads, he may do A, B, C, D. It's very simple.
So you're saying when a person is charged, they must plead.
They have to. If they don't, the Criminal Procedure Act, I just don't get the section now.
Enters a plea of not guilty.
Yeah, so there's no such option.
105.
Yes, it's probably 105, yes. in the
Or any
olden
other,
days,
yeah.
Justice Ismail will remember that the the MK accused used to say, no, we don't recognize this court. It's an apartheid court and what have you. And the court just enters a plea of not guilty. There's no such option. So,
So
yes.
what you're saying is, in essence, when a person appears in a criminal court, usually he pleads guilty or not guilty.
Yes.
But this, or I've already been tried in another forum for the same offense, what the Americans will call double jeopardy.
Double jeopardy.
We call it the acquis or whatever.
Some French fancy name.
The 106(1) plea doesn't apply to guilt or innocence, but it applies to the title of a person who is prosecuting him.
To prosecute.
He's saying you don't have authority
Yes.
to prosecute. That is all.
Yes.
And that is an unusual plea.
Yes, absolutely.
It's not something that appears regularly in the criminal
No.
courts. It appears in certain instances like
Absolutely.
this matter and the other matters you people alluded to.
Absolutely. In fact, any criminal lawyer will tell you 95% you're right,
Yes.
is either guilty or not guilty. But atrophy acquis, atrophy convey, no jurisdiction, pardon by the president, all those up to 106(1)(I are
Age. That's with age.
no,
That's-
I is the last one.
Is it the last one? I'm
Yeah, the
probably
last one.
looking
H
at
is
an old
just
version.
before, yeah. Sorry, I used to teach criminal procedure, criminal law. So I think Mr. Manager might have even been one of my students. I used to set the exams for all the advocates in the country. 106(1). What is more about 106 is that it's even a better, because there's 106(4). 106(4) says if you succeed in that plea of 106(1)(H, you may even be acquitted. So why would any sensible person not do 106(1)(H, which may result in an acquittal, the end of this whole business, if they are right? So let's assume they are right on everything they are accusing us of. They are right that there's no title to prosecute. They are right that there's no interest, the works. Then they should go to 106(1)(H, and then they'll get an acquittal, not some postponement here and what, and then we go to the Constitutional Court and the SCA and what have you. They'll get an acquittal next week. Okay, I'm exaggerating, but they'll get an acquittal within a reasonable space. Which human being, faced with that, except if you want to avoid your day in court, will say, no, I don't want this route that's going to result in an acquittal. I want some long convoluted route that goes via the civil courts and so on. That is what Justice Wallace J.A. was talking about. That this is a tool that is used by prominent people so that who can afford some of the best lawyers like Mr. Manager and to literally just drive all of us around the bend. It makes no sense at all. I'm sorry, Justice Beck.
Yes, if you'll allow just a brief interruption to look at this from a different angle.
Mm-hmm.
And I go back to your quotation of paragraph 9 of Court A.
Yes.
Yes, of the court. And the last sentence, I want to read it to you.
Yes.
It says, to reiterate, the nub of the applicant's case is that to submit to the summons is a violation of his rights to freedom because it is an unlawful summons.
Yes.
Issued by a person without title to prosecute privately. So you are quite right in saying it refers to title, but it looks like the emphasis may be different the way I read that sentence, because it says it refers to the unlawful summons.
Yes.
And then the rest of it is an explanation
Yes.
to say issued by.
Yes.
But the point I'm coming to here, Mr. Mpofu, is this. You can go the 106 route, if I may call it that, if that's the only issue you are alleging, namely title. But if you are alleging other things, such as the applicant, and this is not because I'm not arguing, I'm just putting a question to you as per submissions made by Mr. Maneche, namely that, but in this case, we are not just challenging title, we're also alleging abuse of process, we're also alleging unlawfulness of the summons. And for that reason, therefore, we shouldn't be pushed into the 106 route because, and this is where I put in a question, otherwise I've been referring to the judgment and to Mr. Maneche. The question is it not an antecedent of a private prosecution that the processes that have been followed to reach that stage of prosecution should be lawful?
Yes, of course.
And if that is the case, therefore, is an applicant precluded from saying that's an unlawful process? Me entering the box, or whatever you call it, the witness box, and appearing in court is going to be violating. This is why I refer to the full. This is why I'm quoting violating my rights. So I don't want to reach that point where my rights are violated by that exercise because that process is unlawful, caetic question. And
Yes.
lastly, Mr. Mpofu, I'm informed in posing this question to you by what seems to be an agreement with regard to the facts of what preceded this whole case in your own, or in the first respondent's own admission, in the summary of facts, what happened, nolle prosequi, and so on and so on and so forth. There seems to be an agreement, and you'll correct me if I'm wrong, about the sequence of events in that regard. And
Yes.
if at all there is an agreement, therefore, it means, I want to understand, there's an agreement about an unlawfulness there.
No. I was with you until that last part. There's an agreement about the sequence of events. You're 100% right. So, in other words, there's an agreement that there was a nolle prosequi certificate on the 6th of June, the other one was asked for, then it came, another one in November, and so on. On the 15th of December, the summons was issued, the nolle prosequi was omitted, and the 21st that was rectified. There's 100% agreement on that. But there is no agreement whatsoever on these papers about the lawfulness and otherwise. And most importantly, which is really the nub of the issue, if you really take out all the frills, at the center of this matter, and to the credit of Mr. Maneche, in his heads they acknowledge this, is the question of the interpretation of the nolle prosequi certificate of the 21st of November. That's really, this whole case is about that. But if you work it backwards, and I don't want to enter the merits now, I'll come to that, and it will be very clear that there's no agreement about the unlawfulness. But if you work it backwards, what they're really saying is that there's no nolle prosequi certificate that relates to the president. There's big disagreement about that, but let's assume they're right. And then they say, because of that, the registrar should not have issued the nolle, and they say, the summons, yes. Because of that, the NDPP should not have issued the nolle, and because of that, then they come to what you've said, correctly summarized, Justice Parker. That because of all of that, then the prosecution itself is unconstitutional. But here's the real answer. It is cold comfort for them to say, as you read from that paragraph 9. No, we're also challenging the constitutionality. But all preliminary litigation, it doesn't just say, I'm just here for preliminary litigation. It says, I'm here to challenge the constitutionality of, that's what Justice Wallace said in the SCA. It is commonplace to see in the media that the first step in any criminal litigation involving a prominent person is that they will challenge the constitutionality of the charge or the process leading up to the commencement of criminal proceedings. That's exactly what they are doing. And then he says this must not be countenanced. So their answer can be no, but we're also challenging the constitutionality. But that's exactly quintessential preliminary litigation. That's the first answer. The second answer is that what is these other things that they're talking about? The other things that they say they're alleging is the ulterior motive, right? The former president wanted him not to stand for as a president in the ANC, what have you. But that again converges. That's why I was saying to her ladyship, when you look at the case properly, you'll see that all this converge to title to prosecute and nothing else.
Yeah, so
because
it's grounds on which the title is
absolutely
challenged.
Yes, and you don't have to believe me, believe them. This is what they say. This is what they say in paragraph 91 of their heads, which is at 011-221. Our courts have held that although motive is irrelevant in the case of public prosecutions, ulterior purpose or motive is relevant to determine the prosecutor's title to prosecute. So they are saying even when we raise the so-called other things, the real issue is title to prosecute. And then they say, if a prosecutor pursues a private prosecutor for an ulterior purpose or lacks, or lacks a substantial or peculiar interest, the title to prosecute is lacking. It's them, not us. So let's not, there's no way out. There is no way out. If the case, as they say, it is about title to prosecute, including the so-called other things, then it's about title to prosecute. Where do you get title to prosecute in our law? Section 106(1)H. So, and when does Section 106(1)H kick in? Or firstly, where does it kick in? In the criminal court. When you plead. Full stop. We should all go home at that point. Now, there's no way out. You know, Solomon, my little friend, we have this private joke about his reliance on Solomon. Because I say that it was only 2 years after apartheid came into being, the 1950. But they are misreading Solomon. Solomon is dead against them. Solomon says two things. Solomon says on jurisdiction, and it says that if you have no other purpose except to harass the other side, then the court obviously will have jurisdiction, because the court must protect its processes. Nobody can quibble with that. But that proposition was developed by the Supreme Court of Appeal in the case of Zuma in 2009, where the Supreme Court of Appeal said motive is irrelevant. That's how strongly they put it. Except if it's the only thing. In other words, you can have a bad motive. You can want, let's assume the former president wanted to stop him from becoming the president of Nazareth or whatever. Let's assume that was the purpose. If there is that purpose, but you also want to secure a conviction, it's irrelevant. That's our law, right? That proposition was confirmed by the Constitutional Court in the case of Redell, which we have quoted. We quoted in the Part A head. Redell puts it like this, and I'm paraphrasing to try and save time.
Paragraph?
68. Paragraph 68 of the Redell case says that if ulterior motive, I think the words they use, in on and of its own is irrelevant for a prosecution. Remember, the SCA said for a prosecution or an arrest, it's irrelevant unless if there's nothing else that goes with it.
You're referring to
I'm referring paragraph
Haram's comments there.
Haram's comment
In Zuma versus NDP.
in Zuma versus NDPP at paragraph 37.
Yeah.
And it's qualified at paragraph 38 as follows. Again, another qualification. It says, of course, as I have to concede, and they go to a case, I think of Halstead or something. They say there it was clear that the person who was prosecuting someone, all they wanted was to force them out of business or whatever. Just as in Netco, by the way. In Netco in China, it was clear that this person wanted to extort, for lack of a better word, the bank because he had charged the bank of so-called breaching the Usury Act. But really what he wanted to do was to keep his house and to keep the bank at bay. Nobody, no lawyer can stand up here and say a court under those circumstances must just look the other way. No. But the law, which is binding on this court, is that ulterior motive is irrelevant if they can show, not us, by the way. Again, the question of onus becomes important. If they can show that the former president is lying when he says, actually, I want justice, I want my rights have been violated by all these people, and I want them to be brought to book. They must show that. I don't know how they're going to do it. If they wanted to do that, they should do it in the criminal court. It's impossible to do it here because in this court, it's the civil court, there's something called plus con Evans. So if they want to say that the affidavit of the former president and his letter and all the complaints that he makes are just fake documents, then they must overcome the plus con Evans rule.
But Mr. Mpofu, are they not saying, with reference to all the documents you've just referred to and the chronology of events and their version of who initially former President Zuma wanted to prosecute? You know, the fact that the primary charges arose on the 9th of August last year, and almost only 15 months later are charges brought against the current president. And with reference to the documents, you know, that were exchanged in that time, nowhere is there any indication that the former president actually intended to prosecute the current president. So there are cases that it was on the eve of Nasrec and the prosecution was intended to upset that process.
Yes. Okay.
So does that not bring them within the exceptional circumstances in Rendell?
No, it does not. Because for them to get into the Rendell case, then it means this court must then say, remember, these are motion proceedings.
Yes.
There's an answering affidavit
Yes.
that deals extensively with what you've just put to me, Justice Modiba.
Yes.
What does the former president say? He says, firstly, well, and that's where the NPA's disgraceful conduct comes in. Firstly, in the very first place, on the 5th of April, 2022, the decision that was taken, and I know we're getting into the merits, but it will save us time when we get there. The decision that was taken, my lady, on the 5th, actually on the 1st of April, April Fool's Day, was that they were not going to prosecute any person in connection with this with this. Former President Zuma asks for a nolle prosecution. They dilly-dally. They say, no, you must show Section 7. We had to write back to them and say, no, haven't you read Nandalal? That it has got nothing to do with the prosecutor. You must just issue the certificate. That toing and fro went on until June. For something that takes 5 minutes. You've made a decision on the 1st of April, issue the certificate on the 2nd, for God's sake. But no, it goes until June. Okay, eventually they issue it. They issue it deceptively because it says Mr. Downer, when their own decision said any person. Right? Then on the 30th of September, my lady, we write to them because Ms. Mon in another court raises the issue to say, I'm not in the certificate. Why are you charging me? So we say to them, please, you know you've read all the documents. You know that Mr. Downer is not the only suspect. Issue the proper nolle certificate that covers Ms. Mon. Listen to this so that we come to this date. This Nazareth thing, you'll see that it's just a red herring. We do that on the 30th, my lady, of September. Please give us, and we say, please give it to us by the 5th of October. Why? Because Ms. Mon's case was set down for the 10th of October in Maritzburg. Please give us on the 5th of October. They don't do that. They give it on the 25th of October without even an apology. Actually, they don't even give it on the 25th. They say, no, you are wrong. We only wanted Mr. Downer. Ms. Mon was a witness. Wrong again. It's complete. It's a distortion of the truth. It took then we had to threaten to say, if you don't issue the new certificate, you're going to be compelled to do so in a court of law. Please give us the new certificate on the 11th of October or of November. They default. This time, I suppose we must be grateful, only by 10 days. They give it on the 21st of November, right? The former president tells this court that I received something he has been asking for all year. Now we're told about Nazareth. There was no Nazareth when he was asking about this thing from April, May, June, July, August, September, October. Then he says, when it arrives on the 21st of November, and I can attest to this without testifying from the bar, my team on the 8th of December is going to be arguing the Downer challenge. And then I then say to my team, and this is the only connection to Nazareth, by the way. He says it himself. So I say to my team, let's do this quickly because I'm also going to the conference. Let's get everything out. What is proof of that, my lady? On the 15th of December, the so-called Eve of Nazareth, the former president issued 2 documents. He issued the summons in this matter and the supplementary affidavit in the Karen Mon matter to say, oh, now, after all the struggles, I've now got the nolle prosecution. Was Ms. Karen Mon standing for office in Nazareth? No.
Sorry, I
yes.
need you to address my question,
yes.
right? And my question to you is that their version is that until the summons were issued,
yes.
on the 15th of December, there was no engagement with the DPP around a nolle in relation to the current president. That's
okay.
their version.
No, okay, let me come to that. That's also another smokes and mirrors. The only time that Mr. Zuma could possibly know the truth, that the nolle had been doctored to and narrowed to Downer deceptively, was on the 21st of November this year. And we even knew the dates that I'm telling you about only when the record came out in February. To be honest, we didn't even know the half of the sordid concealment of facts. So Your date, my lady, all I'm saying is that your date must start on the 21st of November, because that's the first time that they come clean and they say, we have declined to prosecute any person in relation to this matter. So the clock cannot start at any other time except when he became aware. When he then gets that certificate, which widens correctly the Amended, which should have been done in April, as it were, he then says, okay, now I've got a certificate at last that even goes beyond what I was asking for. Because if you look at the letters, and I won't go there again to save time, even the letter to Ms. Mon, it doesn't, rather about Ms. Mon, doesn't say, my lady, just give us on Ms. It says, read, it quotes the complaint certificate. It says, you know that we said suspects in plural. You know that we said we are extending this to cover so many other people. We even said the police must look at the scope and look for other suspects and what have you. So it was never an intention to confine it even to the people who are named in the certificate. So the clock, my lady, only starts to run on the 21st. And between the 21st of November and the 15th of December is 2 or 3 weeks. Really, why are we, where is this ulterior motive? Because
that's, in your view, that's a reasonable time to have a summons issue.
Absolutely, especially that time of the year. There's nothing unreasonable in Mr. Zuma saying, look, it's the time of the year, there's going to be DS known, I'm going to a conference, and I want this thing wrapped up, including the current Mon issue. So it's just deception.
You're saying the current president was always a suspect?
Yes, and maybe let me come to that. Let me come to that. My lady, let me just see how I structure my time, because I wanted to deal with that issue when I deal with the merits, but let's deal with it now, because it's as we all agreed, the merits are mixed, they are intertwined. Okay. Now, I was going to wear my lecturer's robe. The problem, if you hear nothing else that I'm going to say, then please hear this. The problem that Mr. By Nature, Ms. Zungu, and I'm assuming now the bona fides, the problem that they have is not to understand the basic principles of our law. Criminal law to start with, and then civil procedure, let alone the fact that they also don't understand review administrative law, where they said you can just ignore the summons at some stage. That really is all that is bringing us here. Here is the thing. Let's look at the nolle prosequi of the 11th. I'll paraphrase again. Everyone has read this document. The November nolle prosequi. It says, my lady, I, Elaine Zungu, having read all the documents, having read the complaint statement, the works, summary of facts, everything that you have in front of you, decline to prosecute any person in connection with this matter. There are two, if you take the endumeni approach of how you interpret documents in South Africa, there are two phrases there. Any person in connection with this matter. So this hyperbole that if you say any person, you mean all 8 billion inhabitants of the world, is nonsensical with the greatest respect. Because I could say any person except those that are in this room, then suddenly it moved from 8 billion to whatever the number of the people who are here. That's exactly what happened here. So it's any person, not just any person in the taxi rank, any person in connection with this matter. Right? So let's go there. Our courts have said that the word any or any person is by definition yes, okay.
Now that you have it in front of
Yes.
you, I'd like you to address the date of the
I'm
charge.
coming to that, my lady. I am coming to that. Believe me, I'm coming to that because that's a red herring. The thing of the date. It also emanates from the thing of not understanding the basics of our law. Accessory after the fact, my lady. This thing called accessory after the fact, by definition, means after. All right. So you can't be an accessory of the after the fact of a crime when it is committed. If you do that, you are an accomplice. That's a different animal altogether. So the date thing is just actually it's a requirement. It's a definitional element of accessoriness that it must be after. All right. So there's nothing there at all. There are two basic rules of accessoriness in our law. One is that you cannot be an accessory after the fact of your own crime. Right? So there has to be a perpetrator. Sometimes, in fact, this is every criminal law book has got a chapter called Participation in Crimes. And it deals with perpetrators, co-perpetrators, accomplices, accessories after the fact, and common purpose. Every book, whether it's Neyman, Hunt, or anyone. Now, what that means is this. For you to be an accessory after the fact, Mr. Manager even repeated it this morning, this mistake, because he says there's a standalone crime called accessory after the fact. There's no such thing. You can't be an accessory after the fact in the air. You are accessory after the fact. That thing that's called the fact is the other crime. It's murder. Accessory to murder, accessory to fraud, accessory to whatever. So there are always two crimes.
But
right?
you're an accessory to somebody else's crime.
Absolutely.
Not to your own.
No, not to your own. Exactly.
Yes.
So
that
here,
is what the definition of accessory is.
Absolutely.
In other words, it has to be after the crime, not that you committed, but somebody else.
Exactly. That's it, Justice Ismail. Those are the two golden rules. After the fact and somebody else. That's why there's that whole thing called the Shriner Doctrine, I think, which is the most mind-boggling aspect of accessoriness. Because our courts have found a way to overcome a very serious problem, conceptual problem. And you'll find that in the cases like Ghani, cases like Palo, cases like Pakane, and so on, where, to paraphrase, a group of policemen, I think that's what those are the facts in Palo. Group of policemen take a suspect to some bush, the person dies, and then they say, we don't know, I didn't kill him. Nobody says they killed him. So the courts then say, okay, now how are you going to, they all were here, they went to hide the body or whatever. So they're clearly accessories after the fact, but the problem is you don't have a perpetrator. So the courts have found something called the Shriner Doctrine to overcome that. And they say, well, you can, all of you can be accessories to the murder, even though artificially we don't know who the murderer is, but we know it was one of you. So that's the exception. But generally, an accessory after the fact means, my lady, that if the crime happens on the 9th, then the accessoriness can happen 100 years later, quite frankly. Because if I kill somebody and I put the body in the fridge somewhere in my basement, and then 5 years later, my child finds that body there and says, oh, I don't want my father to go to jail, I'm going to quickly, I don't know what they do these days, throw into the river. That person becomes an accessory after the fact. to the murder. Maybe they were not even born when the murder happened. But they become an accessory. Why? Because by their own conduct, they have omitted to go to the police and decided to burn the body or incinerate it or do whatever. It's very, very simple, basic. And that's what my learned friends miss. Because they labor under this. Now, that takes us to the following issue. What do we mean by in connection with?
No, I'm gonna curtail your
No problem.
lecture,
Yes.
right? So that leads to Advocate Zungu's explanation
Right.
regarding what she understood as
Absolutely.
what served before her
Absolutely.
when she applied her mind to the
Absolutely.
request for the Noli,
Yes.
right? In relation to who the suspect is
Yes.
and what the charge,
Yes. Yes.
right?
Let's
'Cause
go there.
I don't think there's an issue around the definition of accessory after the fact. When did that charge, when was that charge not only contemplated, but when was that charge laid?
Yes. Okay. I'll promise you I'm going to answer that question in a minute, but let me just finish this thought. Or at least let me get this out of the way. It does not matter zero what Advocate Zungu says to this court. This court's task is to interpret objectively the documents before it, the surrounding circumstances, you applying the rules in endumeni. The fact that Advocate Zungu might not have read this page or that page or whatever, or her understanding of the law is this or that, is neither
She's
here.
the decision maker. I have difficulty ignoring what she says she applied her mind to.
No.
She's the decision maker. She's the maker of the impugned decision.
Okay. The objective theory of our law says this, my lady, even in contract law. I can be the decision maker because I'm the one who signed the contract. And Mr. Manager is also the decision maker, he signs the contract. But when the contract has to be interpreted, that might, the court has to interpret objectively. The fact that Mr. Manager says, oh, well, no, that day I was very tired, I only read 2 pages and I went to sleep, is irrelevant. The objective theory, which applies in any interpretative exercise, says, and it's put in paragraph 18 of Endumeni by the Supreme Court of Appeal, the same Wallace J.A. It says, you look at all the documents, you look at holistically all the instruments, you look at the words that have been used, which is why when you stopped me, I was going to go to in connection with, what does it mean? So you look at those words. Then you say, you answer the question that Mr. Manager raises as a refrain. Does this nolle prosecution relate to Mr. Ramaphosa, yes or no? It's a simple exercise. If it does, we are right. If it doesn't, we are wrong. That's all. So, yes, your ladyship is quite correct, but all I'm saying is that this is not a subjective exercise about whatever Ms. Zungu's weaknesses or forensic skills might be in understanding what it means to say in connection with. Now, let me tell you what it means in this context. The word accessory, even in simple English, means you are an accessory to the offense. That's the fundamental mistake Mr. Manager makes. The charge here is not accessoriness. The charge here is a breach of Section 41(6) of the NPA Act, perpetrated by Mr. Downer. In the absence of the president or Mr. Ramaphosa, oblivious thereof, that's how accessoriness happens. If you read the indictment, and I'm paraphrasing again to save time, it says, my lady, in that the accused, that is Mr. Ramaphosa, is charged for contravening Section 41(6) of the NPA Act as an accessory. Right? How can somebody like that say they are not in connection, you're not connected to the actual, what are you accessory to? When you say in connection with, I decline to prosecute any person in connection with the charge of Mr. Down. Sorry, yes. All right. Now, sorry. Yeah, it's a 001-69. Now, therefore, it says all these things. Mr. Downer did this, and so on and so on. And then it says, now, therefore, the accused is guilty of contravention of Section 41(6)(a) and or B, read with Section 41(7) of the National Prosecuting Act number 32 of 1998 as an accessory after the fact, in that after the commission of the offences, and in or about 21 August to date, at or near Pretoria, he wrongfully and unlawfully intentionally engaged in conduct by commission or omission which enabled the perpetrators and accomplices to evade liability for their actions or facilitated such persons' evasion of liability. That's the example.
Isn't the charge that she says she did not consider when she issued the notice? That's the charge she says she didn't consider.
Well, my lady, I don't mean to be rude, but that is her problem. If she did not consider a charge, if I come here to my learned friend, who's the NDPP, and I say, I'm laying a charge of murder. My sister was killed. And then a month later, he says, I'm not going to prosecute anybody in connection with this murder. What does it matter? That at that time, he did not know that it turns out that my other learned friend here is the one who burnt the body. It turns out that other learned friend and so on. What does it matter? It matters for zero, because the fact that she did not consider that by definition an accessory after the fact is connected to the perpetrator, by definition.
Yes, but so, if I may, Mr. Mpofu, sorry to interrupt you.
That's fine.
I don't want you to depart from your
From the floor,
submission.
yes, thanks.
Just now, the fact that she didn't consider it is not because she didn't want to or she was negligent about it, at least according to Mr. Manager. The fact that she did not consider it arises from the sworn statement by the first respondent, which Mr. Manager took time to take us through, despite that we read it, because he wanted to make the point that in all of it, and I will just summarize, there are people who are external to this case, or institutions like the applicant, like the LPC, and I think there's another that are referred to
The minister.
And the minister, yes. And they're external to it in that they are just being referred to as being involved in investigations or possibly, potentially involved in investigations. And therefore, there is no allegation in that statement that raises them up or promotes them to suspects. What I'm putting to you is that her failure, in inverted commas, to consider it is because there is no statement that's put before her in considering the knowledge to consider whether to prosecute or not. So if that is the question, for you to say doesn't matter if she didn't consider it then and so on, it's her problem as you put it. No, it's not. It's a legal statement to say I didn't consider it because neither the first respondent or anybody ever put a statement that would have exercised my mind to enable me to then bring my mind to consider.
Yes.
So
Fair enough.
it can't just be said, no, it's not a problem.
All right.
Yeah,
All right.
just before you
Let me
respond,
explain. I'm sorry,
I want to
just-
raise a related issue, and that is another ground on which a ground of review the applicant relies. The vagueness of the November, that's very related because she says she didn't consider this particular charge against this particular accused. That accused appears nowhere on the docket as a suspect. Charge is not named, right?
Okay.
So the NOLE doesn't name him. The NOLE doesn't specify the charge, doesn't specify the date it was committed. And this applicant says, for those reasons, it's because it's vague, it's invalid.
Okay. Firstly, the vagueness point is just I don't even know what to call it. The rule of administrative law on vagueness, void for vagueness, applies to, Mr. Manesh at least concedes this in his head. It applies to legislation, right? And he says, well, it should also be applied there. He gives no authority for that. But but how can it be vague? This very same person that we now like, she says, it's not vague. I issued it, and I said any person in connection with the that's a standard form of how nolle prosequi is issued. When there is more than one accused, or when there's all the issues that I was talking about, when there's uncertainty, common purpose, and things like that. I decline to the limiting words, and really this is where I've been trying to get to, are the words in connection with this matter. So there could be, in the olden days, necklacing or whatever it is. And then there's a crowd of people, and there's a charge. If the prosecutor says, I'm not going to prosecute, he's not going to say, I'm not going to prosecute Mr. Temba Mkize and Mr. this one and this one. He said, I decline to prosecute any person in relation to this, either because it seems like flimsy or whatever. That's standard. There's no vagueness. The vagueness is a red herring. That's the first issue. The second issue, and if you don't want to believe me about that, that's a standard, you believe Ms. Zungu on that aspect. But coming to the issue of what she says, Justice Bako, all I'm saying, and I'm not saying flippantly when I say it's her problem, I'm saying it firstly in this context, this following legal context, that the interpretational exercise is by its nature objective. Let's at least agree on that. That's basic. Okay? So that's what I'm saying. So that's why I was making that example of Mr. Manech and I being signatories to a contract. That's number one. Number two, this person that we must now believe is the same person who lied to the court, is the same person who said when there's a nolle prosequi that says any person and narrowed it to Downer. Is the same person, even upon inquiry on the 30th of September, when we said, of course, Ms. Mon is included, who wrote back 25 days later and said, no, she's not. She's the witness. Lied again.
I mean, Mr. Mpofu uses words which are not contained in any of the documents before. I mean, that's unfair. I mean, to say the DPP lied. What's the basis of that?
Okay.
I mean, you should not submit arguments from the bar. It's really unfair, because that may call for me to reply to the innuendos and insinuations that he's making. Does it please the court?
All right.
It's a factual allegation you are objecting to, right?
that's
You
correct.
just said argument.
No, I thought the objection is that it's not in the papers. Well, I'll use a word that is in the papers. The conduct of the NTPP is disgraceful in this matter. That is in the papers. Why? Because, and I'll find it for you. Why? Because she, having been told, even in this court, even in the court in Maritzburg, these things really, they get an opinion from Mr. Trenkov that says Mr. Zuma clearly has an interest. And they go and argue here and there that he doesn't have an interest. They get an opinion from Mr. Trenkov in Ms. Zuma.
I mean, that opinion is not before the court.
It is.
No, it is. It's even dealt with in the affidavit.
Tell the people that they believe this is becoming a joke.
All right. 008-106.
Mr. Mpofu, before you proceed,
Anyway, I'm sorry.
proceed, you seem to have a constituency at the back.
No, it's got nothing to do with me.
Sorry, Mr. Mpofu, because each time you make certain submissions, there is a response at the back.
Well, it's simple. Either they behave or we clear them out.
Yes, that's what we need
Because,
to
you
address.
know, this has been going on and we've ignored it. This is not a circus.
Yes.
This is a court and we're going to appeal to you after this. If anybody behaves in this manner, you know, applauding and clapping hands and behaving, please respect the court.
Okay. Oh no, I thought it was addressed to me. No,
No, it's not to you.
No, thank you.
We've seen it earlier, and I mean, you know, these are adults seated here, we know, but we are appealing to them.
No,
And this
thank
is serious matter, and you know, this is not going to the movies and when you see something you like and you know, people behave as if it's a circus.
I share the sentiments of the court. This is an extremely serious matter.
Correct.
Thank you, madam.
I felt tempted to say this earlier, but I thought, you know, it will peter out. But it seems to me that it keeps going on, getting worse.
Yes.
I think it's important that they've heard, Mr. Mpofu, that you agree with this directive.
By agreeing, I'm not owning it, but I'm simply saying I agree with the court. Yeah. No, where was I? It was on the opinion 008-106. I'll paraphrase again to save time. Mr. Trengov, in an opinion that is in the papers, says the following about the prosecution at that stage of Mr. Down. He says you have three options. You can challenge, if there are grounds to challenge ulterior motive, you can challenge ulterior motive. As a standalone, not in this way that has been challenged as an adjunct to title to prosecute. And he's right. Well, he's not right, but let's say on a narrow reading of Solomon, he's right. And I'll explain why Solomon actually doesn't say anything of the sort. He says the second option is you go to section 106. Oh, sorry, the recording. Yes. Thank you, madam.
It's 4 p.m.
In any event,
we're going to
it's a
ask
sign.
you to round up for the day. It is 4 p.m.
Yes, it is 4 p.m. So I just, if it doesn't come back, I just wanted to finish just this thought so that I don't.
It will. Let's wait.
As court visits, I'm indebted to the court. Thank you. Thank you, my lady. I'm really indebted to the court. I just didn't want to stop mid-sentence to...
The machine is still off.
Oh, it's still off?
Yes.
Okay. Well, I think it will flash. Yes, I think we're back. Wait, no? Okay, thank you. I'll be less than 5 minutes. I just want to round off this point. Firstly, the opinion you'll find at 008, the relevant part 008-103, and it goes.
Do you have a specific paragraph?
Yes. The one that I referred to about the interest is paragraph 17. That Mr. Downer unlawfully, if we assume Mr. Downer unlawfully publicly disclosed Mr. Zuma's private and confidential information, then Mr. Zuma probably does have a substantial and peculiar interest in the issue arising from the injury he suffered to his privacy and dignity. That's, as we know, one aspect of title to prosecute. But this is what they say at the end, the punchline of their advice. All of this might sound as if we believe that there's a case against Mr. Downer, but of course we know that there is none. I don't know how they know that, but they know. The remedies by which he can protect himself against unlawful prosecution would include the following. 1, he may launch an application to interdict the prosecution on the basis that Mr. Zuma has instituted it for ulterior purpose. 2, depending on the formulation of the charges, he might challenge Mr. Zuma's standing to prosecute him under Section 71A by raising a plea under Section 1061H of the CPA. 3, he can simply plead not guilty, as he will undoubtedly be acquitted for the reasons fully set out in the judgment of Justice Kuhn. So, we agree. Subject to the qualification about the Solomon's case. But because of time, I will, let me just say this just to assure the court that we actually have made progress. Although I was originally addressing the point in limine, we substantially...
Sorry, I need you to deal with the issue arising from the objection. right? The point is that she's disgraceful. That's what you delivered,
Yes.
and you're substantiating.
Yeah, oh yes, I was substantiating.
I don't want us
that.
to lose that.
Oh yes.
Okay.
Yeah. The reason why we said the conduct in the papers we say is disgraceful is the following, my lady. It is more than obvious, and this makes my spine to shiver, that we can have an office of the National Director of Public Prosecutions in a country like ours that can behave in the following fashion. And this is all in the papers. There is a private prosecution, let's start there, of Mr. Downer, who admittedly is one of them, so you can expect the bias is already manifest. But what do they do, my lady? On the day that Mr. Zuma lays his charges, the NPA issues a statement saying that there's nothing wrong with Mr. Downer. They have confidence in him. He's a man of integrity, what have you. Fine, that's wrong enough. But let's say they don't know now that this thing can get more serious. Mr. Downer now gets charged. The NPA issues statements from the court, sponsors his legal representation openly, and basically supports him. What is that? In terms of Section 12 and Section 13 of the Criminal Procedure Act, if Mr. Downer pleads guilty in the private prosecution, the NPA must step in and carry out the prosecution. Must. So if he pleads guilty, what are they going to do now? Now that they've said he's innocent and they've paid for his legal representation, are they going to sponsor his legal representation and also prosecute him? That's disgraceful. They don't stop there. Former President Zuma issues a summons against former President Ramaphosa, current President Ramaphosa. There is the haji-baji about the letters, no, you didn't put the certificate and so on. The NPA, Mr. de Kock, the deputy, issues a media statement saying, well, this time I'm going to use the word, giving a lie. Because that lie says that let me just get it to it. It's FA 12 to the founding affidavit. Yes, 001-217. And I've got it. The NPA, of all people, says, the NPA takes note of media reports relating to the summons issued in respect of President Ramaphosa. As background, the NPA issued 2 nolo prosecute certificates in good faith and in compliance with Section 7 of the Criminal Procedure Act. These certificates were issued in direct relation to the docket, which contained statements and affidavits relating to specific individuals. That's let's not elevate it. That's just factually wrong. It didn't relate to specific individuals. For alleged contravention of Section 41.6, read with Section 41.7 of the NPA Act, that part is correct. Then they say, the nolo prosecute certificate apply to any persons who are specifically mentioned in the docket. So we say thank you for that. Then they say, the president was not mentioned in any of the affidavits or statements, and thus the certificates were not issued in relation to him. A blue lie. The president is mentioned in the complaint certificate, He's mentioned in the affidavit. He's mentioned in the annexures. There's a letter addressed to him specifically. He even responds to it. It's just a lie. But let's assume it was
But
true.
it's in dispute here. That
No, it's not
issue-
in dispute. That is not mentioned. You go to paragraph 17 of the statement that Justice Pakwa was referring to. You'll find that.
But the question whether the NOLE applies
No, no,
to
no.
the president or not and
No,
the
no, no,
charge.
no,
Is
please.
it not an issue here? No, Mr. Mpofu, I treat you with utter respect. I'm engaging you on the issues. I've got no predisposition. I'm a judge appointed in terms of the Constitution, exercising my functions without fear, favor, or prejudice, right? And I'm engaging you with respect. I expect the same.
Yes, my lady. My lady, I just wanted to say that it can never be. How can it be in dispute whether Mr. Ramaphosa has mentioned in a statement? It's a document. It's here. It's not. There's no one who can dispute it. At least Mr. Manesha doesn't dispute it. I don't know if your ladyship says it's disputed. Then I don't know which of the parties disputes now, apart from this.
I'm referring to the NOLE prosecute certificate, not the statement. The NOLE prosecute certificate, that it does not. It's in dispute. That it mentions him and it mentions the charge that he's now asked to face. That is in dispute here. Is that
Okay,
not
my
so?
lady. All right. Maybe it's me. Maybe it's late in the day. Yes. I'm reading a statement, a media statement. I don't know what that has to do with. I'm simply saying a sentence in this document is a lie. All right. That's all I'm saying.
Yes.
And the thing that I'm saying is a lie is not in dispute by any of the parties in this courtroom, at least.
Okay, please read that statement.
Okay. So, they say the president was not mentioned in any of the affidavits
Yes.
or statements,
Yes.
and thus the certificates were not issued in relation to him.
Yes.
Right?
Yes.
So it is, okay, I don't know. It's untrue.
So, sorry, Mr. Mpofu, you were beginning to read the next sentence.
Yes.
That says the president is mentioned as if to qualify that sentence. Can you read that also?
The way he's mentioned.
Yes,
Yes.
the sentence after you just said the documents don't refer to the president.
Yes.
And then you were saying the president is mentioned.
Yes.
Can you continue?
Oh, yes. I'm sorry, yes. That's where I was going actually when I just got. That you will find Justice Pakwa at different places, but it is in the statement of.
No, in the same statement you read.
No, there's no such thing. I was not going to read from this. I was saying, remember, it says, Justice Pakwa, the president is not mentioned in the affidavits or statements. So I can't, to refute that, I must go to the affidavits or statements
Please
to show
do.
that this is a form
Yes,
of
please do. Please
Okay.
do. Because
Yes.
you're using very strong language which has been objected to. Please do. We're dealing with an officer of this court.
All right. The statement, the 009?
110.
Okay, can you give it to me? Statement of I'm sorry, just 008-55. All right, I just want to get the
008. Is that the annex or the affidavit?
That's the,
The
my lady,
annex.
that's the
Is that-
that's the affidavit, the complaint affidavit. What we refer to as the complaint.
It's the current president supplementary affidavit.
Yes, my lady, I think. But it's one of those things that appears in many places. Okay, let me do this. Let me shortcut this. If you go to our heads, because these are quoted in our heads, my lady. Sorry. Yes. Right. Paragraph 20, from paragraph 22 of our heads, 23, we quote the complaint statement, which you will find at case lines 009-146, 001-68, and yes. But let's use the heads one for speed. It says, in his complaint affidavit, Mr. Zuma made it abundantly clear that the suspects against whom the charges were being laid extended beyond Mr. Downer, but also, quote, to cover all other persons as reflected in the documents attached above, who are either prosecutors and investigators who have violated the provisions of the NPA Act and the Constitution. Then we then say, it was also made clear that the conduct complaint was not only confined to the alleged contravention of Section 41(6), but also, quote, to extend to other criminal activities. Then at 25 we say, it was specifically and expressly contemplated after investigation, the scope of the criminal conduct which would be uncovered would go, quote, beyond the criminal conduct involving the leaking of confidential information to persons outside of the NPA, showing the violations of Section 41 by prosecutors, investigators, and other persons who are directly or indirectly involved in Mr. Zuma's case. And here's the part that you wanted, Justice Park. Most significantly, this paragraph 26, it was stated that, quote, the alleged conduct, and Mr. Maineche himself, when he said this, he correctly said, that means the criminal conduct. That's what he said this morning. The alleged criminal conduct also forms part of separate investigations which are conducted by the President of the Republic of South Africa, Mr. Cyril Ramaphosa, the Minister of Justice, Mr. Ronald Lamola, and the Legal Practice Council. So let's at least get that clear that he's mentioned there.
Can I just I want to make this point before you move so that you can address it. All I was saying to you, what you've just read is your client's version on these issues. So these issues are in issue in these proceedings, right? And for that reason, it is inappropriate to be labeling Ms. Advocate Zungu as a liar in respect of the issues that this court has been called upon to pronounce on.
Lady, I think we're talking at cross purposes. Firstly, it's not Advocate Zungu. It's Advocate Rodney de Kock,
yes,
head of the National Prosecuting Services.
Yes.
But my lady, I will leave this point. If any human being in this court is going to say that this statement, let's use the old format, true or false. The president is not mentioned in any of the affidavits or statements, true or false.
Is not mentioned as a suspect.
No, but that's not what this thing says. It doesn't say anything about suspects, my lady.
In any event, this court does not have to rule on that statement, right?
I give up, my lady.
Yes, so
okay,
the direction to you, Mr. Mpofu, is that toned down on your
Yes.
language.
Okay.
There is an objection that there is no allegation regarding any member of the prosecution authority lying in these proceedings.
Okay.
So don't make that statement from
All
the
right,
back.
okay. A member of the prosecution said the following: the knowledge certificates apply to any persons who are specifically mentioned in the docket. That is true. A member of the prosecution also said the president was not mentioned in any of the affidavits. I'll leave it there. There's nothing more I can say about that. If it's true, it's true. But let me put it like this, to come back to the disgraceful conduct. True or false, the mere act of issuing a public statement in support of a criminally accused person who is criminally accused in the courts of South Africa by somebody in the National Prosecution Authority is a disgrace. True or false? Let's forget about the fact that it's false now. Let's say it's all 100% correct. At what point does a National Director of Public Prosecutions, who's an independent office, issue a statement defending an alleged criminal somewhere in Springs or whatever, except if that person is also the boss who's the president of the country, and you only issue this statement on the 21st of December 2022, when it has become clear that he has been re-elected. You don't issue it on the 5th, 15th, you don't issue it on the 16th, don't issue it on the 17th, don't issue it on the 19th, issue it on the 21st. I'm saying, my lady, and really this is where I'm going to leave it. Assume that I'm wrong, that this is untrue, that the president is not mentioned. Assume for a minute. Which country would countenance a situation where the prosecution behaves like that? How are they going to, again here, if Mr. Ramaphosa pleads guilty or whatever happens, and they have to step in terms of the law, having issued this, what is this?
Yes, I think the point is well made.
Anyway, there's more, but we don't have time. The point I'm simply making is that and really this was in response to Justice Parker's point, that my ladyship called it the decision maker or the author of the statement. Fine. But one who has behaved like this, even if the test was not objective, even if the test was subjective for interpretation, anything that is said by these people must be taken with a large amount of a dose of a pinch of salt, because they have taken sides at various points of this. They have behaved disgracefully outside of the prescripts of the United Nations guidelines on prosecutorial independence, outside of our own act, the NPA Act, which calls for independence, outside of Section 179(4) of the Constitution, this one, which says...
Yes, before you go to that section, Mr. Mpofu, my sister has already indicated that in the language that we use in the context of what's happening in this court, we must add some moderation in this sense. For instance, the document that you just read from, which refers, yes, to the president not being mentioned.
Yes.
My sister mentioning that this is contested. The contestation is around whether he was mentioned as a suspect or he was not mentioned at all. So I'm sure, without trying to lecture you on the language that needs to be used, if there are inconsistencies in some of the submissions or statements and so on and so forth, we could put it that way. But to categorize issues as lies, a conclusion, in other words, from your client's point of view, that it's a lie, because we still going to hear from Mr. Mainenje and other counsel whether that is in fact something that is untrue or whether they would give an interpretation that gives another view. So it's all about moderation
And
language.
Mr. Mpofu,
I don't know why we're going back there. I've said, I've actually been changed. I said it's false or it's an untruth. But I can tell you, as my name is my name, that if there's anyone, and I'm inviting my learned friend, Master Manesh at least, who can show that the statement that says President is not mentioned in any of the affidavit or statements is the truth, then I will not only withdraw from that statement, but from this entire case. If anyone can show me that when I've just read it out to the court, and says Mr. Cyril Ramaphosa, and if anyone can show that it's actually true that is not mentioned. And by the way, the response, what I'm saying is not even my own view. It is something that is in the papers. Because what happened is that the former President Jacob Zuma's foundation issued a statement in response to this. And it's part of the papers. And it said exactly that I'll get to it now. If that is F812, then it is probably F813.
While you go there, Mr. Mpofu, I've listened to your submissions regarding the conduct, the alleged conduct of the members of the office of the DPP. And those allegations are quite serious. We will apply our mind to them.
I know.
And if any deprecation is justified, this court, I will assure you that this court will not shy away from expressing itself on that conduct.
My lady, that's what I call a hallelujah moment. Because that is all, quite frankly, we have asked for in our answering affidavit. We said in our response to Advocate Zungu's affidavit, we call on the court simply to say something deprecating that conduct.
Yes,
and so then if it's justified, I'm happy.
I was directing you regarding is your language. That's it. Yes.
All right, I'll change it again. I first said when Mr. Matibedi stood up, I considered his objection. And I said I'll use a word that is in the papers because that's what he called me to do. And I did that, so I don't know what more I'm supposed to do. The second issue, after that, I can't do more than concede his objection, really. The second issue, which I'm prepared to die for, is that this statement that the president was not mentioned in any affidavit or statement is false. That, I don't care what happens about it. It is not true as a statement because I have read out, there's a letter addressed to him. He is mentioned in the witness list. He's mentioned at paragraph 17. He's mentioned in the affidavit of Mr. Tusini. He's mentioned in the answering affidavit. So that I'm sorry, I can't.
That point is well made. You are addressing conduct. You're not vilifying any person. The point is well made.
That's all I'm addressing. Yes, thank you. So, but anyway, I was saying section 179(4) of the Constitution says there is a single national prosecuting authority in the Republic structured. National legislation must ensure that the prosecuting authority exercises its functions without fear, favor, or prejudice. That means without bias, without taking sides, without issuing media statements that support alleged criminals, without doing any of the things that I've catalogued. without narrowing nolle prosequi certificate, without raising spurious points that are refuted in Nandalal, and without delaying the issuance of a nolle process from April to November with delaying tactics, and then say, no, it was on the eve of Nazareth. To turn around, please. If that if we can't, there is no justification for this by anyone, and no amount of sugarcoating it is going to make it acceptable for anybody who cares about this thing.
Okay, I'm going to ask you to round up for the day.
Yes. Okay, all right. What I will then do, my learned friend is the timekeeper of the teams. So firstly, she wanted me to confirm that if we are still starting early.
Tomorrow. We
tomorrow.
started at 10 today.
We started at 10, but
What does the practice note say? What time are we
they
supposed
said
to start
10, but there seemed to have been an agreement of 9:30.
No, we followed the practice note. We were ready. We did indicate that we.
I did think there was a confusion. We were here.
We are willing to start early, but your own practice note said 10, so we followed that.
Yes. No. My learned friend assured us this morning that the message had gone through, but it's obviously an error. So I think let's forget about the past. Can we tomorrow start at 9:30? That's really because otherwise we'll be.
Is it fine? Yeah.
All right. Now then, let me then round off my lead. Now this is what I'm going to do. I'm really going to have to go back to this. I want to leave the court with just one thought. Accessory. I have found the words. It means in addition, add-on, adjunct, an appendage, or a supplement. Just in normal language. In law, it means that one of the participants in the crime. And I'm going to start tomorrow by addressing the court on the substantive principles of criminal law around accessoriness and participation, to answer one question and one question only. Can it ever be said under the sun that a person who is charged as an accessory after the fact to fraud is not connected to the fraud? Can it ever be said that if someone who is an accomplice, for that matter, or an accessory to murder is not linked or an appendage, a supplement, or all the words that I've just said to the fraud? If the answer to that is no, then we will stop in 5 minutes tomorrow. But if the answer, as we suspect, is yes, then the statement that says, I decline to prosecute any person in connection with this offense must be read in the endumeni fashion, objectively and irrespective of what any one of us have to say about it. That's why we have courts. The court is here to say, okay, this one says this one says this one says this. But objectively, what does this document say? Because that's what this case is about. Is this nolle prosequi certificate applicable to this particular accused person? Finish and clear. Once that question is answered, all these other things will unravel. If we are correct that it is applicable, and these are just legal gymnastics to try to dodge out of it, then we must succeed. If we are wrong, and in fact he's not mentioned and all these other things, and is not even contemplated as a part of the crime at any level, then we're wrong. That's it. That's the court.
We're adjourned for the day.
All right.
Shall we go?
Left at the side.
I